My lord,
This you have filed.
Lordship, so Lordship may indicate
December.
2 working days, my lords. 2 working
Because
days.
tomorrow is Saturday, Sunday.
My lords.
2 working days. Yes.
Grateful.
my lord, item 13 on behalf of Mr. Mahanti, he is unwell.
13.
My lord,
What is this matter?
passing of cognizance.
Cognizance, there must be nothing. So therefore you are seeking adjournment.
My lord, he is unwell.
Then counsel for the petitioner submits that the leading counsel is not well. Which one is recommendation? Please, next week.
Obliged.
Pardon, Lordship. I am custody more than 8 months. Lordship, in the meantime, 2 of the accused persons are on anticipatory bail.
Bail matter, serially it will come. You give it,
Right.
it will come. It is 2024, 23.
My lord.
24. When have you filed the
Lordship,
petition?
PLPL number 55.
Tell me the date.
Date I not recall.
You must know which month. Which month?
January.
January. Then it will come. Next week it will come.
My lord.
Yes. There is no. None. Yes. Second one. Yes, sir.
Petitioner challenges the cognizance order to Annex 1.
Yes.
4 on 14, my lord. It is arising out of a 1cc case, my lord. And the cognizance order at page 15, the
Yes.
statement of complainant under section
Show me 200 complaint.
at page 16, my lord.
16.
15,
What are the allegations against you?
my lord.
What are the allegations?
Allegation, my lord, that the affair has been given for there is a construction of
asking you where the complaint petition.
Complaint is at page 18. What are the allegations? Read it. You are Hanuman Prasad, huh?
no.
No. You
I
are
am
Vishwajit Das.
Vishwajit Das.
Vishwajit Das.
Okay. Hanuman Prasad is the complainant.
No,
Witness,
Gayatri Devi,
witness,
Gayatri
witness.
Devi.
There are 2 witnesses.
They are witnesses.
Gayatri Devi.
Hanuman and Ganesh. witnesses,
Ganesh, my
And
lord.
you are Vishwajit Das.
I am
What are
the
the allegations? Just see. Read it. See whether there is any allegation is there or not. And in 200, what are the statement made
Right.
against you? These are the 2 things I have seen.
cognizance has been taken under section 294 and 506, my lord.
You say that these cases are not made out.
Not made out, my lord.
Then that is you have to argue that on the charge stage.
My lord.
Charge stage.
Already evidence has been taken, my lord.
Charge has been framed.
Framed, my lord.
So then, what can we do? You telling that charge?
My lord, in her 200 statement, my lord, 200 CRPC statement, my lord, she has stated that occurrence took place at 1 p.m., my lord.
ये सब you have said that मैंने तुमको नंगी करके घुमाऊंगा
हाँ.
ये all these things you have said.
That has been there, my lord. But in her evidence, I have also annexed, my lord, at deposition copy
Yes.
at page 23, my lord. In her
Not evidence.
Come to page 20, para 2. Page 20, para 2. Abuse me saying, तेरे को नंगी करके
that is 200 under
That's
section.
right, that's the statement under section 200.
That is a statement.
And complaint is there, complaint the same thing, and in statement the same thing. What else for cognizance?
That is there, my lord. But at her evidence, my lord, at page 23, my lord.
What is this then, page 20?
20 is
The statement of the complainant recorded under section 200 CRPC. What is this? Enough.
different statement, my lord. Here under 200 CRPC, she has stated that तेरे को नंगी करके घुमाऊंगे such and such things. Whereas at 23, page at 23, annex 6 series, my lord. Nowhere she has stated that that language, my lord. And
He might have said that filthy language.
no filthy language, my lord. So, and also in her
Para 2, page 23, para 2, last line. Then he abused me in obscene language. That's all.
that obscene language, But specifically, she has stated that they are at 200 CRPC that तेरे को नंगी.
That particular language she might not have said, but the fact is she says that obscene language, and in 200 in the complaint she says a particular sentence, and in 200 statements she says particular sentence, and in here he says that obscene language. What for cognizance? What
My
is
lord, on that particular date of occurrence, my lord, so the present petitioner, who is a practicing advocate also, is at Kotak, my lord. I have also annexed the
that plea of alibi?
my lord.
Plea of alibi that has to be proved.
I have filed the documents, my lord.
Where is the charge? Show me the charge.
Charge टा mo file कर mo to Cognizance order टा file करছি ମୁଁ.
Then you
And the statement
but
are from the other
charge has been framed or not?
that must be framed, my lord,
Must
because
be, no. Then you argue all this point at the relevant time. Right on.
Minor.
In the present petition is seeking petitioner has challenged the order dated 4/1/2014 passed by learned SCGM declared in ICC case number 48 of 2013, whereby the court below has taken cognizance of offences under sections
294 and 506.
294 and 506
my lord.
of CRPC. I have perused the
There is
complaint
civil-
under section 202 and the statement recorded by the recorded by the trial court under section 200 CRPC. I am satisfied that prima facie against the petitioner is made out for the purpose of taking cognizance of offence. Accordingly, I am not inclined to interfere in this matter. However, liberty is granted to the petitioner to raise all his defense and the points he has urged before this court at the appropriate stage of the trial. With this observation, the petitioner is disposed of. Yes, next.
My lord, what I am is a practicing advocate. That's why till
Right, advocate doesn't mean that you
in
can say
that
all the things
particular-
to a lady.
in that particular court also, and till the disposal of the
That's more of a reason that he should face it.
maybe protect
The
how-
decency is expected more from a lawyer at the bar.
uh,
And if the lawyers are starting using this kind of language against a women,
no, my lord,
Or
that's a
anybody-
false statement. He is at
that is to be
and
taken.
the civil suit is pending, and civil suit also disposed in
All-
favor of the petitioner, my
All
lord.
these things are trials, sir. In Cognizance, I think you have resorted to wrong proceeding. What to do?
My lord,
I have given that liberty.
the liberty, but till
That
that
liberty is
period,
there, you can argue all this.
till
Yes.
that period, he shall not be taken
Sorry?
in coercive action, my lord, or protected.
You are not on bail. If they are bail,
Till then,
you have not appeared before court.
no, my lord.
Then I'll say that you will appear before court, and if once you appear and
No action.
your bail application will be decided on the same day without further delay.
Cope-
Or you tell me
appear before
you
the-
tell me what you
He
want.
can
Being a
file
lawyer,
205 application also there, my lord.
Huh?
205 also file can file.
205 application also go.
That may be allowed since advocate.
That may be
It.
And then comes for the petitioner further at this stage further submits that the petitioner is a practicing advocate.
in that particular court also.
In the same court. There are checkered history between the petitioner and the complainant. Complainant as civil disputes are pending.
No, already disposed of in favor of petition.
Civil disputes are there between the parties.
Previous-
Between
say
the
true.
parties. Therefore, he submits that he submits that the on instruction that his client would be appearing or surrendering before the court and seek remedy under law.
Under 205.
He may do so on or before 30th of August 2024 Until then, no course of action shall be taken. That extent I can. And you immediately go and move so that till 30th you will not be arrested and you will be released on bail. Yes.
Obliged.
Item 2.
Yes. This order is not actually permissible. Still I have done because he is a lawyer.
Inherent power, my lord.
That's right, but see, we have to have a balance. This is the anticipatory bill, actually. Anyway, being lawyer, he is entitled. Yes. Yes, sir.
My lord. My lord, last occasion, my lord directed to file the certified copy of the marriage Nikanama, my lord. Kindly see
What is the
pa-
case? Let me understand.
My lord,
No.
passing of criminal proceeding under the ground of they have been married and the last occasion, my lord, on 14/5/2024, my lord, they both parties had appeared before this honorable court
Where is that?
and
Let us see, read that one. Registration of opposite party number 2 FIR shown to registered. And the allegation against the petitioner is that the opposite party number 3 is a victim and the opposite party number 3 is the informant, father of the victim who has lost the FIR for their saying that the daughter of the person have studied and he was in medical space. Where are they?
My lords, I may be permitted, my lords. I am appearing for the OP number 2 and 3, my lords. On the last occasion, previously, my lords, on 14/5, we have filed the joint affidavit before the Honorable Court. The parties were present and they were identified and they also filed their Aadhaar document, my
The
lords.
Aadhaar card, but they should be, I don't know, this is on May, in the month of May.
Yes, my lords.
We
They
are
were
in
present.
July.
Both sides were
These
present.
these kind of young people, every third day they change their mood.
And the
Well, for-
They don't take marriage so seriously.
petition also juvenile by the time of
So they don't take,
Trans.
they are young people, they don't take
70
marriage
70
seriously.
once.
My lords, they were present.
You
14/5.
let them come. I'll quash it, but let us see them once again. Whether see that girl is happy or not, let us see. Okay, I'll the Nikanama, photocopy of the Nikanama is placed on record, is filed by the petitioner, no? For the petitioner, which is taken on record. Let the party be present in the court. Release the date. Release the 7th, 8th, next week only. Next week. Let them come.
My lords, a longer dead miller, the boy is staying outside millers. A longer dead may be better millers.
Longer date.
Millers. Longer dead millers. And millers, the petitioner that my brother should place for the other side that he is not on in protection. So in the event he appears miller, he may be taken in court. That party lordship may take care of.
No. Settlement, why? You're asking now, there are a lot of ifs and buts will start. If you have settled the dispute, they are
Yes.
married, let them come, I'll quash it.
But the police also at present searching for the boy.
No, police will not do. So the order dated 14/5/2024. It is very clear. Yes.
So your lordship post,
My
lordship,
Date.
Clarified. Anticipated liability was rejected for that.
May I have lordship?
Hmm.
The petition challenging the order that impugn order dated 1/8/2021, that is annexed to page 14 for taking cognizance under offence under section
Yes.
409/34 of IPC, my lord.
Yes.
The petitioner is a government servant, the manager of the FCI. At the, what has happened, my lord? On the incident date, the 15 truck were entered into the storage
Hmm.
for lifting the goods. The informant came to know that from the photo and video, the one truck went out after loading. Other 14 trucks is there. Thereafter, investigation is completed, and it is certain that the 280 bags of wheats is taken out from the truck, my lord. The petitioner, as the petitioner is discharged of his duty, the official duty, my lord. At that time, he was a manager of the FCI, but now the lower court below, he took cognizance under section 409 as a government servant of the petitioner without sanction, my lord. 197 of CRPC, my lord.
Let us see whether the act complained of is coming under the duty, official duty.
Yes, my lord, official duty. At that time, he was on duty.
No, he may be in the duty. In the duty, if he murders someone, it doesn't come and does it come under the color of duty? You have to see what kind of allegations are there. Whether while discharging his official duty, if he has done something, then the sanction is must. Let us see what are the allegations.
At that time, my lord, he was
Come to page 11.
page 11, my lord.
Allegation. On 31st July 2020, there was a program. of
My lord.
Scheme of
There is a program issue in
according to
PMJY
which
scheme.
were entered into the godown for lifting up for the stock, the main gate, with a proper entry gate registered. But it is revealed that reported from the photo and video clip that one truck bearing number so and so had been entered into FSD Reniala along with said 15 trucks
My lord.
and went out after loading the wheat and without proper official entry. Accordingly, the very truck was there except the said truck.
Except the said truck, all trucks are present there, my lord.
On receiving the information about the incident, immediately investigation was done by the regional office, and on that day, it was found that all the 9 CCTV cameras were switched off from so and so to so and so. Further, on the next date, on so the team compared the so and so investigation after investigation of the depot and staff and our from the side. It is asserting that 280 bags of wheat had been taken out from the depot by the sector question. According to the departmental proceedings have been initiated by an fire officer and the staff and the sponsor also. The sector for the question.
The last
Yes.
part, my lord.
Yes,
They have not given this copy, just copy of that.
but I think there was a departmental proceeding initiated and all. It
Yes,
is
yes,
a maybe a dereliction of duty. Direct involvement is not there.
And only
I
Cognizance
issue
letter.
notice. I issue notice. This,
Madam.
it needs consideration. I just issue notice. Issue notice. Yes.
CD.
Issue notice. Give a copy. Let us examine it. Okay.
My lord. My lord, till then, the further proceeding maybe.
No. I will not stay.
My lord, initially he was suspended. Thereafter,
That is
reinstated.
See, I am just giving little indulgence because
My lord.
I have seen that the allegation they have initiated a departmental proceeding also.
Yes.
I just want to know what is, and short date I'll give. Good week next week. Yes.
My lord, till then,
No till then. Thereafter nobody will come. I know that. It will be pending after 20 years. You will find these matters are pending. I'll dispose it up in your favor. I have some point in your favor,
my lord.
and the moment they file it, I'll pass it straight away. Why are you asking for stay? If you have a good case, that's all. Prepare little bit because there is a departmental proceeding
My lord.
and there is no direct allegation against you.
Yes, yes, my lord.
So there may be a dereliction of duty. If it is a case of a dereliction of duty, then it's coming under the color of duty. Then sanction is required. So that part you concentrate. I've seen it. Okay, next.
Item 4.
4. One.
May I
Yes.
please, my lord?
Yes.
My lord, challenging the order taking cognizance under Annexure 3
Yes.
on the ground that there is an amicable settlement and whole of the amount of 2,10,000 has been repaid to the complainant.
There's 138.
Yes, your lord.
Settled.
Matter has been settled, but the crux is that the complainant is demanding for the interest amount.
How much?
How much he is claiming for 1 lakh?
You show me where have you paid in lieu of the check which you have issued.
Lordship, I have taken a specific stand
Where is
in
it? Now,
para.
stand. I'm not in the stand. You show me the document where you have paid in lieu of the check, the entire amount you have paid. On the basis of pleading, I will not decide a criminal case.
Lordship, one thing I may
You may say
suggest,
whatever.
as because since there is
That
already,
has to be tested in the trial only. If you say something.
my lord, it is only the part of the interest amount.
That's right. Show me. You said that the check amount you have already paid. Show me one document.
Lordship, I have already in para 7, your lordship. Para 7.
Again, you are
Lordship,
not able to
I'm just
follow.
coming to my lord.
Some document would be there. Have you got a receipt or anything?
Then I have to collect that material, your lordship.
This is the only thing you have. 40-page petition, you have not filed the relevant document.
On good terms, and I have already paid the amount. And
I don't think I need
and
to.
it can be,
I don't think I need to educate you in this.
lordship, it can be settled through mediation.
Then you settle it. Who stops you? Go to. Is pending in the trial court.
Yes, yes, yes.
Right on. The petitioner has challenged the.
Lordship, make
1 minute. I'll give you that opportunity. Petitioner has challenged the order dated 3/7/2018, passed by learned JMFC Jaipur in 1cc case number 58 of 2018. In the whereby the court below has taken cognizance of offence under section 138 NI Act against the petitioner. Petitioner in the present petition in para 7.
Yes.
Para 7 of the present petition, entry alia has stated as under. Where have you said that you paid?
Lordship, in para 7, outstanding amount is
Para 7 para 7 entry alia stated that. Regard being had to the fact that the petitioner is contending that he has already paid the check amount. I am of the considered view that the trial court should give an opportunity to the petitioner and the complainant to evolve a settlement on by way of mediation. Therefore, I am not inclined to entertain this petition. However, I relegate the petitioner
till mediation process.
to the trial court for exploring the possibility of settlement between the parties with this observation the petition is disposed. Yes.
Lordship, till the mediation process till ended, there should be a no coercive or stay of the further proceeding.
Are you not aware of the fact that 138 are bailable offences?
Yes, yes, I
For
know.
heck of it, you are asking. I have given everything to you.
Only for stay.
What say? Why should you say I'll stay?
Till mediation process is ended.
Then that court will.
ସେଟା ତ ଆଜ୍ଞା ଗୋଟେ ମାସ ଭିତରେ ବି ସରିଯିବ.
If I have given a direction to the court that he will explore the possibility of settlement, it will be settled. I have recorded your that paragraph also.
In that period, if
I think you have got more than what you are supposed to get. Be happy with that. And
for a limited period, I am saying. Lordship, may kindly.
No, this why there should be some genuine thing to ask. Why I'll stay the proceeding? I am not interfering in the cognizance order. I'll relegate you to Trial court, you do whatever. I will.
No, your lordship,
I
only for
am
that.
not interested to interfere in cognizance order in a 138 matter. You have not placed any document on record to show that you have paid. Still, I have given this indulgence on the basis of your pleading. You be happy and go and settle it, this student, and pay little. It's a matter of a few thousand rupees. Pay and finish it up. Yes. Yes. Next. Anybody is there?
Passing over Cognizance, my lord, 376, yes. There's 2 years.
376.
And 6.
When was it filed? October 2020.
Right.
So it will just pass over, so then we'll dismiss it. Nobody comes. Yes.
Please, Lordship, now the matter is already settled between both the parties. And the initially, Lordship, the
What are the offenses?
initiated
Huh?
offense initially under section 363 and subsequently turned to 376 3 and
Minor girl.
6 6 at
Minor
17. Yes, Your Lord.
First
Yes.
case, counter case, your lordship.
And Your Lordship, another case that is PS case number 16 that has been already quashed by the coordinator, honorable coordinator bench, Your Lordship. I have annexed that. So Your Lordship, I
That is the
pray,
cross case.
yes.
Cross
So-
case filed by the boy against the girl.
No,
Girl's
the
come-
mother-
No, father,
Father of the girl.
victim. So I pray Your Lordship kindly call for next week any date and the parties will be present before Your Lordship so that
What is
matter
the
will
stage
be
in this
settled.
case?
Now Your Lordship, the already charge sheet has been filed and cognizance and taken.
Charge has been
Charge of
framed.
framed, Your Lordship.
Where is 164 statement?
Your Lordship, I have already filed as for Your Lordship's direction,
Show me.
Charge sheet, enter charge sheet file.
entered charge sheet.
By the way, what was the case you filed against the father, which has been caused? What was the offense?
After
That is
knowing
the,
fact,
that-
your lordship.
No, what was the offense there?
yes, yes, yes.
Three
I have annexed, that is,
I know you have annexed. I'm asking something.
yes,
307 was.
307,
307.
yes.
That is caused.
Yes.
yes.
That is also equally a serious charge. Okay. Show me the 164. Let us see. Everything you start research,
Yes.
study, and everything you will do in the court only.
No, no.
Pass it over. Find out. But these are these things should be in your tips.
No, I'm sorry.
No, next pass over. Next.
Copy maybe, sir. Well, copy maybe, sir.
Item number 7, may I please your lordship? I am in
Copy
BC.
right now and pass over. We'll see.
My lord, I am
By
in
the
BC,
time
my
you
lord.
keep on searching 164, I'll finish 2 matters.
Yes,
One page, 1, 2, 3 page searching out.
no.
Young man, you should read it first and come. We should be the tips. Yes.
May I please your lordship? My lord, I am in BC. My lord, I have an innocuous prayer here, my lord. My lord, though I have filed this application for seeking passing of cognizance, I just confine my prayer for a limited prayer that your lordship may direct the trial court to dispose of the trial because 2 of the petitioners are government servant and one is a student after passing out the examination now trying for, but because of pendency of the
That's
criminal
right, but
case.
it is a case of 2023.
My lord, but tribal by magistrate, my lord, your lordship may direct target it.
If I'll pass, I will accede to your innocuous prayer, the order will also be innocuous thereafter.
No, my lord, I just yes, because
How
my
many
lord,
witnesses? Let us see
My
how many
lord,
witnesses.
my lord, there are in the I have said in the charge sheet there are 18 numbers of witnesses, including the officials.
What is the stage now? Charge has been framed.
Charge has been no, not after cognizance. Only cognizance stage, man.
Oh.
Because it's a by magistrate will try. It will not be committed to the sessions court.
See, the problem
Offense-
what I look, see, the problem is there are about 4 accused.
Yes.
Now, how many accused?
Yeah, there are 4 accused persons.
No. Please.
No,
come.
7 accused persons.
No. Please come to page 12.
10 numbers,
There are
11
11
numbers.
accused.
11 numbers, party.
Sorry. 11 numbers of accused. Pardon.
Oh, so that's the whole problem.
11.
Three of you
No,
have
no,
come and
all have been appeared, all have been released on bail by the court below.
That's right. What I'm asking something else.
Yes,
Three of you have come here.
yes,
If
ma'am.
I pass an order for expeditious disposal of the trial, the other people may not cooperate. And the trial
No.
court will be in a very difficult position. High Court says, dispose it up. The other accused persons are not
No,
coming.
let your lordship pass that order. If that eventuality will come,
I
we'll
will
see.
only say that as expeditiously as possible. To that extent, I can very well do
My
it.
lord, difficult,
I
one
can't
thing,
target it.
no, what I beg to submit, my lord, here your lordship may kindly see item petition number 2, who after conclusion of
I
his
know, I understand
graduation,
it. I understand your
he is-
difficulty.
he-
But the
because
problem
of
is-
this pendency of the criminal case, he is not getting, and absolutely no evidence. My trial will, evidence, I am not going to that because I don't want to go for at this stage. But what I have examined, the evidence are very shaky in nature and it may not stand in the trial. So,
why don't you argue all these things before the court at the stage of framing of charges?
Yes.
so after
that,
framing of charge, after, yes,
Number two, maybe discharge also.
no, my lord, what I beg to submit that let it be trial be concluded. So first going for a year and then charge all these things.
Targeted burden over the court below.
Hmm?
It will be a targeted burden
Hey.
over the court.
So let it be, my lord. August.
Cognizance is taken away. I don't know when the charge will be framed. Today I'll target it.
No,
We can't
your lordship,
sit on the high trial
no,
court.
your lordship may say one thing. Let him consider the charge first. After that
he will do it.
That your lordship may say within a period of.
And do you think that without framing charge he'll convict you?
No. I mean, that is
will be
exactly.
fast only.
I completely agree with your lordship. Let him.
And what I'll do is within 1 month charge should be framed. That
Yes. And there we can also say to the court. There we can say to the court for targeting the trial.
Right. Okay. Right.
All right.
The petitioner is agreed.
It will be good.
Order dated 23/8/2023 passed by Leonard JMFC Keshinga in CT case number 91 of 2023. At the outset, Mr. Acharya submits that he would not be pressing this petition. Rather prefer to argue all the points before the trial court at the stage of framing of charges. But he is apprehensive of the fact that the trial court, trial would be prolonging for a longer time. The petitioner number 2 is a young man. His entire career is at stake because of the pendency of the present case. Therefore, he seeks indulgence of this court with a direction that the trial court should do well to see that the trial is concluded as expeditiously as possible. Since the charge has not yet been framed, it is difficult for this court to target the conclusion of trial at this stage. However, the prayer made by the petitioner deserves merit to the extent that the trial court shall proceed expeditiously for the purpose of framing of charges. Accordingly, I direct the JMFC also to hear the petitioner on the question of charge and proceed with the framing of charge if it is made out. If it is made out within a period of 1 month hence. 1 month hence.
Obliged.
Okay. Yes.
Limited prayer, my 457 application is pending since July 2023 before the Vigilance Court.
Which application?
Annexure 3 application, page 27.
Your application under section
457.
Why it is not decided? 1 month. Right up. The petitioner is agreed by the fact that his application under section 457 CRPC for release of what?
For release of different
those in release that cannot be released.
Whatever that is on
Let him declare.
release of various
articles
seized, various
in paragraph number 5 of that
articles
petition.
seized, is pending since
since 10/7/2023.
10/7/23. He seeks indulgence of this court for a direction for expeditious disposal of the same. Since the application is pending since October 2023, I'm of this court is of the considered view that the trial court should do well to decide the application on merit within a month hence. Within a month hence. With this observation, the petition is disposed of. Yes. Item 9. Yes.
May I please, your lordship? In the
Yes.
present case, the petitioner challenges the cognizance order dated 24/2023. Lordship, the present case arises out of a dispute between employer and the employee. And lordship was pleased to,
What have you done? Show me. 354A, 354B.
so far the allegation against present petitioner is concerned, there is nothing in the record, your lordship. The present petitioner only instructed another employee, that is Padmavati Viswal, to ask the victim to stay in the office.
109 is there.
Your lordship,
109 is there. 34 is there. What to do?
not made out against the
Let
petitioner.
us see what are the allegations. The
Page 15, my friend.
harassment of women in the workplace.
Lordship, the present
Basically.
petitioner was not even present on that day.
So these things we have to very carefully look into. Yes, let us see what are the allegations. Parental report alleging that on 7/11/2022 daytime, when she went to her office, one of her office staff, namely Padma, stated that branch manager Hari Narayan
Yes, your lordship,
Anand.
present petitioner.
told her to stay in the office. At that time, one Jyotirmoy Mandal arrived at his office, and when the complainant went to the kitchen room for changing her dress, Jyotirmoy Mandal forcibly entered into there and tried to keep a sexual relationship with so and so and so. Who are you? Jyotirmoy?
No, your lordship, I am Hari Narayan Andia, your lordship.
Jyotirmoy is item 63.
Jyotirmoy is the prime accused, your
But
lordship.
what manager has said? Manager said that you stay in the office. What is the wrong in it?
Yes, your lordship.
But again, 164 statement has been taken.
Let us see 164.
My
The
lord,
manager
what
only
happened?
says, you stay because he is the manager, he will say the staff stay in the office
Yes,
for
your
some
lordship.
time.
The
And when
present,
she stayed and went to change her dress to a place, kitchen, some other accused has come and got hold of her and
Some other means another staff.
another stuff. But what he will do, has he instructed, do it?
yes, your lordship.
Or how will you relate, how will you connect the manager role with the role of this gentleman who has outstayed the modesty of the women?
That
Re-
164 statement has been
So,
taken.
for me,
164 he has not.
deliberately he has asked her to stay in the office or something of that sort. So,
Fine. From the order sheet manually reflected, 164 statement was recorded.
read it. Page 15, come to page 15.
15 is the FIR.
FIR. Okay. FIR is the same thing.
Yes, your lordship.
Plus the FIR, your lordship
So,
was-
Kalabele, it is not even in the
the late
night
hours.
or working hour,
Yes.
morning time. So, Kalabele, ମୁଁ ମୋର ଅଫିସରେ
ଦେଖିଲି ଯେ ମତେ ଅଫିସରେ
ଦେଖିଲି
ରଖିବା
ଯେ ମତେ ଅଫିସରେ ରହିବା ପାଇଁ ମ୍ୟାନେଜର ହରିନାରାୟଣ
Andia,
ଅଣ୍ଟିଆ
Andia.
ପଦ୍ମା ଦିଦିଙ୍କୁ ଫୋନ କରି
ପଦ୍ମାବତୀକୁ କହିଲେ what is wrong in it in the office hour you will not stay in the
Your
office.
lordship,
What?
the
The
present,
manager will not say that this much. 164 yeah,
164 was recorded, but it is not in the file. Lordship,
where is 164 from?
we do not have, your lordship. I've done.
Get the 164 set.
Your lordship,
Entire case record, you know.
Nothing is made out against this man.
Well, that you will verify from the case record whether any allegation is because.
So what do you want? Shall I issue notice and no court
yes,
case?
your lordship.
Your lordship
In
call
the,
for the second.
Call for the CD, huh? Call for the CD.
your lordship, similar situated co-accused person, this court was pleased to issue notice. Lordship.
Notice करके तार से लगा दी. So when that matter is coming up?
Four
Who is
second,
similarly situated according to you?
Padmavati Viswal, your lordship. Your lordship, co-accused person.
Why are you bargaining risk by getting yourself attached? You have a better case. Why are you linking yourself? This is
As
bad strategy, I tell you.
As a lordship.
This is bad strategy because Padmavati has something and you get attached, then 109 is basically proved. You instructed Padmavati, Padmavati said to her, And when she was there, another staff attacked. So link is established. So you independently pursue case. Don't attack. Don't attack. You have a good case independently. Don't bring Padmavati and all. Let her face whatever you want to be.
And my lord, is item 63 that that accused.
Hurry.
Another.
63 but also urgent, my lord. Another urgent.
See, they don't have a case. You have case. You have a case.
63.
Simply urgent karo CD magao. Huh? What will happen, you know, all the matters will be tagged, everything will be dismissed one day. So better that independently you first. Yes.
He was the liberty to array the OP as informant.
Yes, yes.
I may permitted to do the same in court.
Liberty, yes, yes. That 354 you have. Huh? Okay. Yes. Next week they call the CD. Yes.
Item
Yes.
10, my lord.
10.
My lord, on behalf of Mr. Tripathi, I pray for an adjournment, my lord.
What is this matter?
Ma'am, I don't have the file, my lord.
Let us see whether it deserves adjournment or deserves dismissal. What?
Well, he's not in court, my lord, due to illness. He hasn't come.
Cognizance order again.
Cognizance is
21 cognizance is taken. By now, trial might have been over also.
My lord,
I'll just pass it over. Just ask what is the stage of the trial.
I'll inform him, my lord.
Stage of the trial, at least let us know.
Right.
If the trial has already proceeded, charge has already been framed, I don't think pending of this matter will serve any purpose. You just ask.
another CRLMC was filed by the present petitioner. That is 4205 of 23. Pending for what purpose that CRLMC was filed. That may be tagged.
Man, I'll inform him, my lord.
Then let us put it on Monday then. Tagging, yeah?
CRLMC number
Tag and Monday
4205.
will dispose of that.
Right.
Okay?
God bless you.
4205.
Next, 11. Yes, madam.
Petitioner prays of passing the summon election, which is issued on 22/9/2023.
Someone.
Yes, sir. Petitioner was on bail.
Here is to
Yes, sir.
Why? Someone.
Because on 22/9/2023, petitioner was absent before the court below, for which cognizance has been taken.
If the cognizance is taken, then
Cognizance was taken.
the
notice to
secretary is someone is issued. You want to appear?
Yes, sir. Bail.
What are the offences? Explosive substance.
Yes, sir.
These are non-bailable offences. What?
Petitioner.
41. He was
Petitioner? What?
Petitioner was released on bail.
Why do you worry? You won't appear.
Yes, sir.
on bail. Then charge sheet was submitted.
Then he will
Court
go and
issued someone to appear. That someone is.
right now. The petitioner is agreed by the order dated 22/9/2023 passed by SDGM Koraput in GR case number 787 of 2016, whereby after taking cognizance of offences, the trial court has issued summons to the petitioner. Learned counsel for the petitioner on instruction submits that his client would be appearing surrendering before the court below, appearing before the court below on or before 30th of August, 30th of August, and seek remedy under law. He further submits that during the investigation, the police had given 41 notice to him, and he was never arrested in the present matter. In that view of the matter, he would be moving appropriate application for admitting him on bail. If such application is moved, the same shall be considered on its merits. Yes. You will be extended that
bail
Agarwal judgment is there and everything. Sushila Agarwal. Yes. Please put up. Yes.
My lords, in item 12, I'm appearing virtually in this matter, my lords. My lords,
Yes,
I'm
madam.
praying for a short adjournment to take instruction from my client because, my lords, this matter was filed sometime in November and I had heard that there's some talks of settlement going on. My lords,
No,
we were
this
basically
is,
moving.
This is regarding quashing
Of an FIR, my lords, purely civil dispute between two corporate houses regarding a purchase of a property in Mumbai. My lords, I need 2 weeks' time. I'll take instruction. Either we'll pursue it or we'll withdraw it, depending on the settlement.
Okay. Then counsel for the petitioner yes.
I see only 259 page. Page 259. Annex of 40.
40, 14, 14,
1.
14, okay. Yes.
A notice was issued to the petitioner to produce the documents.
No, what she said is, it is a interstate dispute between two companies. They want to settle the dispute. They might have settled also.
And
So,
cooperated with the investigation. That is the purpose.
why are you, there is a complaint that you are not cooperating with investigation.
My
What
lords,
is the matter?
the audio is absolutely, I cannot hear the state counsel. I'm unable to follow what he's saying.
No, what he says is, he has pointed out, annexure 14.
Yes.
And says that notices were issued to you and you people are not cooperating with
My
investigation.
lords, let me take, because I have not got any instructions since the summer vacation. The matter is subtly shown up. Please kindly give me 2 weeks' time. I'll take instruction if they're not cooperating.
Are you settling the dispute? Shall I
My
record
lords,
it?
that was my instruction given to me because my lords, Khaitan and company has actually engaged me in this matter. They had told that talks of settlement. This suddenly it has come up in the list. The list came at 10 in the night. I'm unable to take any instruction.
Problem.
So kindly give me 2 weeks' time. I'll get back.
Yes, then counsel
Mamta Tripathi.
Mamta Tripathi and counsel for the petitioner submits that before summer vacation this matter was filed. Therefore, she has no instruction as of today regarding the same. However, before the summer vacation, he had oral instruction that the parties are intending to settle the matter. She wants to ensure about the present status of the matter. Therefore, seeks 1 week adjournment. Please.
My lords, 2 weeks. My lords, may kindly make it 2 weeks.
Okay, 2 weeks. I'll list it after 2 weeks.
All right. All right. That'll do.
Item 14.
14.
Oblige, my lords.
Yes, sir.
Item 14. My lord, petition prior to release the vehicle, which is seized under the Odisha Excise Act. Now the vehicle is released by the JMFC Bhubaneswar, but confiscation proceeding which was initiated by the authorized officer till today, my lord, is pending. Directed to conclude the confiscation.
Vehicle is with you. Let it be pending. You enjoy. If that order that is concluded, if confiscation is made, your vehicle will be taken up. Why are you asking all these things? Vehicle is with you. Enjoy it. Let the confiscation
But
go on for eternity. How does it make difference to you?
My lord, if confiscation proceeding is not concluded,
You will
then
not sell it.
Not sell it.
You don't sell it.
That is the basic
You
problem.
don't sell it. Wait. Wait for some time. There is no direction is required. The vehicle is released, so therefore the confiscation proceeding is going on at its own. Right on. You withdraw it if cause of action still survives and approach this court. Okay. Right on. Then counsel for the petitioner seeks to withdraw this petition at this stage with a liberty to approach this court if cause of action still survives. Still survives. Still survives. With this observation, the petition. If confiscation proceeding is concluded and then some order is passed, you can come. Okay. Yes. Yes.
My prayer is for quashing of proceeding by GR case number 107 of 2022. My lord. It's a matter about marital dispute, my lord. 498 allegation or along with 294 just
what is happening in the
my lord,
marriage front?
Sorry?
Marriage front, what is happening? They are
No,
separated?
they are separated since 2021, my lord.
Any divorce proceeding, anything?
No, my lord. There is a chance. There will be chances of settlement, my lord.
Shall I?
My lord, the thing is that where all the cause of action arose in Mumbai, but intentionally the FIR was lost after 1 year in Hinjli, my lord. And
She must be staying in Hinjli.
Hinjli is her parental house.
This is the usual story.
No, after 1 year, my lord. After 1 year of the cause of action, the FIR was lost. And in the investigation has already been completed.
You are very lucky that after 1 year it is done.
Why, sir? How could I be lucky, my lord, since the proceeding is going on?
See, if in a matrimonial dispute, if something happened to a girl,
And I think
do you think that today something goes wrong, immediately next day she will lodge an FIR. Obviously, she will give time. She will always expect that the husband or the in-laws
No,
will
we.
fix their way. Things may.
When second birth of the Ghana came, all these things.
Nothing was in the worst situation. If everything goes wrong, then only they go to police. Generally, this is the.
No, me and my mother went her to get back, but she refused
That
to.
can't be a ground of quashing. If
No,
you
no,
want to settle.
Oh no.
Dispute, what I can do is I can send you to mediation right here.
Well, your first of all, the notice should be sent because I have read.
See, I'll tell you the mediation. I'll issue notice. I'll ask the mediation center to also issue notice and settle the dispute and finish it up. There is no question of quashing.
My limited prayer is GRK's subsequent proceedings should kindly be stayed unless because there is chances of settlement. So it's a 498 allegation and your lordship see the investigation.
You not filed the divorce petition also.
No. Kindly be stayed because it's 498 allegation because
where is she staying? Where is she staying?
She is staying in her parental house in what is I think it is in Hinsley, my lord. Yes, Hinsley. Aska. No such no such torture as your lordship.
Okay, it's all right now. Marital dispute, why to unnecessary
My
complicate their life? Right now. Issue notice to the opposite party. Number 2. So accept notice for stay. Counsel for the petitioner submits that this being a this matter is arising out of matrimonial dispute. The parties, if opportunity is given, the parties can explore the possibility of settling. Taking into consideration the statement made by the petitioner to the bar, I think it is appropriate to send the matter to where it is pending. Where are you staying?
I stay at Mumbai.
Yes, but you have to pay the expenses for the purpose of this lady to come to High Court for meeting. Okay, right on. Sending the matter to the Orissa High Court mediation center. Accordingly, the present matter is referred to Orissa High Court Mediation Center. The coordinator of the mediation center is directed to issue a fresh notice to the opposite party number 2 for the purpose of by fixing a date for the purpose of exploration of settlement. Exploration of settlement. The petitioner shall bear the expenses, travel expenses of opposite party number 2 for the purpose of appearing in the mediation center. The petitioner is directed to deposit rupees 10,000 to begin with.
10,000 to the expenses.
You are giving to your wife only. This 10,000 will be instrumental in settling the dispute. She will think that my husband is so good paying 10,000 rupees. Pay 10,000. How does it make difference? 10,000 for the to meet the expenses, travel expenses and staying expenses of the opposite party number 2. Go with a positive note so that things will be. And awaiting mediation report after 2 weeks.
The subsequent proceedings would
yes. In view of the aforementioned, the further proceedings in the so cases stayed till the mediation is concluded.
That's item 16. Press admission for criminal appeal. Let's see the
sentence.
Sentence 2 years.
And same order. Realization fine stayed, bail granted, appeal admitted. Yes.
LCR we called for.
LCR. Mr. Sanjay Das names are reflect in the court case.
Let's see.
He copy of the order.
That is regular order. Yes.
17.
Made.
Yes.
Lordship, the petitioner filed this
What is
challenging the order dated 2/4/2024 by the Lord Special Judge.
What are you filing here?
That's why,
Charge sheet document. Lord.
You file it in the counter.
in
Why
fact,
are you-
I shared the same thing with my Lord sister. She is very much acquainted with this too.
Wait.
And Indians,
Gone are those days now. Now,
the important is I quoted Lordship statements that why you keep it? I don't have the file. So it's
where will it give? That's the whole difference. You give it in the throne somewhere else.
correct.
And when the matter is taken up, we keep on searching the file.
No, she
Let
understands.
the counsel for the petitioner seeks wish to file what?
Additional affidavit.
Additional document to substantiate her case. She may file the documents within 2 working days. Link matter. Put to be next week. Next week, next week. Okay, file it. And advance copy of the documents and supplied to Mr. Yes. Then after 5 minutes.
5 minutes.
Passover may not be possible today. Next week. Yes.
So
Yes.
date, my lord, date.
19th.
Oh,
Next week. 19th.
oh, village lords.
Yes.
19. Next week.
Yes, Mr. Raghunath, what is this?
19, my lord. Here, my lord, 372 I-302, my lord. Rape and murder, my lord. And Poxul there, my lord. 5 years gal has been.
What is the stage of the trial?
My lord, till date, my trial has not been commenced, and the
Man of Andhra Pradesh, my lord.
quantity of
Casualty not there, my lord. So the antecedent case.
For case date. Yes.
My lord.
Next.
criminal antecedent also. Criminal antecedent.
Criminal antecedent also. You are from Andhra Pradesh. There is no problem. Once granted, you will not come.
My lord,
What is the recovery? 100.
50 kg, your lords.
50 kg.
And
Outsider, yes.
21 prisoner petition as well. My name may be reflected in the call list.
Tell me what is the case.
Actually, file mata asini. Today, prisoner petition as filed wakalatnama also. Next date, I will argue the matter.
Judgment on the ground that this is instructed to appear for the petitioner, he will be filing wakalatnama on behalf of the petitioner. This next week. Next week, 23 matter, na?
Madam.
All the 23 matter within this week, next week. 23 sub. But CD our target is to finish within 2 days.
Two set of he is appearing on behalf of Mr. Jena, but she said that the prisoner sent a petition from the just
No,
to engage her, my lord.
our 20 number ta hochi on behalf of Mr. Jena. 21 re kindly.
You are appearing for 21 or 20?
21.
But he says that he will appear.
prisoner petitioner batla tapona na re.
Prisoner petitioner, my lord.
Flag F, my lord.
Ha. Bhakalat na file karchi.
Flag B.
Flag kintu.
Since in custody, my lord, the
Flag B, yellow.
prisoner petition should taken.
Bhakalat na madhya file karchi.
Who will appear?
Both of them to decide, my lord.
No, flag kindly glance at flag B, my lord. Jana rache ta.
Let us see what is the case. Let us understand.
NDPS kindly adjourn this.
No adjournment. There are 2 advocates still asking for adjournment. You tell me what is this matter? 2023 is pending unnecessary.
Alleged offense
you can renew a bail plea in the trial court. Meanwhile, evidences are already recorded. The rejection order is. Where is the rejection order? Yes, the rejection order is at page 24. And in October 2023, your bail plea was rejected. And about nearing a year or so.
1 quintal 54 kg and
kg.
900 grams.
Huh?
1 quintal 54 kg,
So you
900.
can renew a bail plea there. Charge sheet has been filed, and what is the stage?
The charge sheet has been submitted. There is no charges are not been framed, or 15 months above he is in custody.
Charge has not yet been framed.
Not framed. Enter quantity was the seizure of the joint possession of the accused persons, and seizure was prepared under section
My lord, what
50
happened
of
this
the
case,
Act.
my lord? Other 3 co-accused persons, my lord, they have also filed their bail application that is pending, and CD might be available in that case, my lord. That is BL appeal number 752/2024, BL appeal number 5319/24, BL appeal 185. All the cases, my lord.
Take this matter along with those 3 matter and list after 1 week.
My lord, BL appeal 752/2004.
Tag and list after 1 week.
I would BL 5395/2004. BL appeal 1851/2004.
The bail application of the co-accused persons being BL appeal number so and so pending in this court. Tag this matter along with that those matters and list after 1 week. Yes. Next.
22.
May I please your lordship?
Yes.
And here the petitioner is in custody since last, my lord, 13/11/2023, and charge sheet has been filed under section 376(1), 294/506.
Yes.
I'm supplying the charge sheet copy.
Don't supply the copy.
Yes,
But CD is not available.
You
Once
file
for requirement.
You have to file it.
Yes, I'm 164 is
Just
there.
don't have that practice of throwing paper on the court. You file it.
Yes, I will file it, my lord. I'm
This matter is pending since 2023. You filed it in December 2023.
Yes, my.
Now when the matter is called up, you are showing some paper.
I'm supplying, I'm filing.
Why have you not done earlier? I will send you to trial court, move press application.
My lord, let this, I'm supplying, my lord, short adjournment.
Why adjournment 2023? Why are you not realizing that what is happening in bail application? The High Court is not able to decide for 1 year. That is the message we are sending.
Yes, ma'am. CD.
Why it
CD
is not disposed of? Because of the non-cooperation of
CD is also not present, my lord.
And the High Court is getting bad name.
CD is also not available.
You forget about that. You argue on merit.
Yes, my lord. I am supplying the check.
Argument made.
Yes, my lord. Allegation is that the present petitioner has, while the victim lady has attained to call,
Not filed anything except rejecting application FIR, there is nothing.
had gone to attend call of nature, the present petitioner came from backside and.
Show me that charge.
Yes, madam, charge.
If you have a merit, then I'll entertain, otherwise I'll send
Yes,
you
ma'am.
back. Yes. Show me which page.
Present petitioner came from backside and committed sports. Huh? 164 touch is it?
Yeah.
Dekho
Where is that? 164?
164, my lord.
Page. Yes. Read it.
Yes.
ମୋ ସ୍ୱାମୀ ମରିଲା ପରେ
ଆଜ୍ଞା ମୋ ସ୍ୱାମୀ ମରିଲା ପରେ ମୁଁ ମୋର ବାପା ମା ଘରେ ରହୁଅଛି। ଗତ 9/11/2023 ତାରିଖ ସନ୍ଧ୍ୟା 7ଟା ବେଳେ ମୁଁ ଆମର କ୍ଷେତକୁ ଝାଡ଼ା ଯାଇଥିଲି। ସେହିଠି ତେଜରାଜ ବାଗ ଦ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ଆମ ଗାଁର ଲୁଚିକି ମୋର ପଛକୁ ଆସି ମତେ ତଳେ ପକାଇ ଦେଲା ଓ ରେପ୍ କଲା ଆଉ କହିଲା
Quantity of ganja is 420 kg. Petitioner is in custody since 9/7/2023. My lord, about 9, they got information that a huge quantity of ganja is being transported by the petitioner and others. On getting the information, they went to the spot and found 4 motorcycles on the spot, and in each motorcycle, 2 bags are being tagged. And the others, out of 14, 6 were on the roadside, and 9 persons were there. These the petitioner and others were standing near the motorcycle. On seeing the police party, 9, they tried to flee away, but the petitioner and another, they were arrested.
What is the stage?
My
My
lord,
lord,
in this case, my lord, from
I
at
called
the
you,
time of
Sato,
filing, my lord,
only
since-
3
since
witnesses have
12/2/23,
been
my
examined.
lord, time frame, he is in release on the interim bail. my lord.
Yes.
That's right.
For that is the case that has not been received.
That's right. But what is the stage of the?
My lord,
My lord, take
stage
instruction.
3 witnesses have been examined,
Out of?
and out of kete mo paake seita
Out of the
information
tell
nahi.
me. Out of how many witnesses?
City has
All must be the official witnesses.
My lord, your lordship may kindly turn to page 13.
1-3.
Yes.
Yes.
Page 13, second para, first para. On weighing the bag, number 1 with ganja, it became 30 kg, 200 grams. So each bag was having 30 kg, 200 grams.
So you say that 60 kg.
60 kg. And apart from it, my lord, I don't have any criminal antecedent. I have no criminal antecedent.
You tell me the trial. State.
Case is not available, my lord. Since, my lord, as because it's the time to release on interim bail, my lord.
And I am
Instruction called for from the IO, and the instruction came, my lord, that his wife. suffering.
Interim bail granted by this court.
Time
Yes.
to time, my lord.
no, twice, not time to time. On the ground of illness of wife.
You have shown your good conduct.
Yes.
By
Yes, that is another factor.
Is it not a point that you should go and tell the trial court that see, High Court has given me interim bail, and
No, they will not.
I was diligent to come back and
They will not entertain.
I'll record it and I'll relegate you to trial court.
No, my lord, it will not
We call
give
for
me
call
any
for
benefit.
citizen. If you want, then I'll have to see the chief. Here.
Oblige.
Huh? Oh, take a look, sir. But ideal would have been that I would have recorded that twice the interim bail was granted by this court, and this accused has
Shown his good conduct.
not misused the
Liberty.
surrender. In that view of the matter, the trial court should look into the matter afresh on merit. That would be a better option for you to try. And in any case, you will have to come back to this court if they don't give you. And the court of first instance should apply mind on merits. That would be an adding ground for you.
Vigilance kind of duty.
That would be an adding ground for you. That's why.
My lord, we can take a chance. That.
Here also you are going to take chance. Also.
Yes, we can take a chance.
Take chance in the court of first instance.
Court of here also, and after here we
So
can
you
take
never
a chance.
know that chance may work. You will get two chances.
There are no chance.
And add those things so that may,
It may obey with the court.
So,
Your Lordship may pass that order. Let me
that's
take.
better idea. Right.
Yes, Your Lordship may do.
Item, Kudatala?
23.
23, yes.
Yes.
When the interim bail was granted.
I have
First-
filed, first, my lord, I have given twice,
First interim bail.
I filed the surrender certificate, my lord.
The surrender certificate. By order dated, by order dated so and so. The petitioner was granted. The petitioner was granted interim. The petitioner had in compliance with the order of surrender and filed the surrender certificate in the court, which is taken into court. Mrs. Sujata Janal and counsel for the prosecutor submits that although the entire recovery in the present case is about 4 quintals.
420.
400 quintals. However, the prosecution
kg 420 kg.
420 kg. However, the prosecution story indicates that there were about 9%, and there were about how many?
9 persons.
9 persons.
14 bags.
And 9 persons alleged to have been carrying about 14 bags, each bag containing about 30 kilos.
30 kg, 200 grams.
And even if the prosecution story is accepted at its face value, the recovery from the petitioner would be at best 60 kilo.
400 grams.
400. Therefore, he submits that the petitioner is entitled for bail on 2 counts. Firstly, the recovery is about 60 kilos, 400 grams, insofar as the present petition is concerned. Secondly, the concession of interim bail granted by this court is not being misused. Rather, in timely he has surrendered before this court.
And
looking into her conduct, timely surrender before this court. Apart from the fact that the petitioner has a clean antecedent, on these grounds, the counsel for the petitioner insists that this court should grant bail. I am not inclined to entertain this petition at this stage for the reasons that the trial court has rejected the bail plea of the petitioner way back on. When rejected on. When it was rejected.
Yes, I have 5.
In the prayer, you people don't write. That's the whole difficulty.
My lord, order is.
Keep on searching.
No. My lord, page 20, 12/7.
Tell me.
12/7.
12/7.
23.
23. 12/7. 20.
Page 25.
It would be appropriate for the petitioner to renew his bail plea before the court below. Liberty is granted to the petitioner. Court below on the grounds as mentioned above, and other grounds on merits as well. If such application is moved, same shall be considered on its merits.
Oblige.
I think that would be a better way of
putting things.
Right.
Oblige.
24. May I please, Your Lordship? My lord, the allegation is under section 302 of the Indian Penal Code. The name of the petitioner does not find place in the FIR. 2 petitioners are there.
Charge sheet filed?
Only, my lord, only on the circumstances, my lord.
Charge sheet
filed.
You are there.
My
In the charge sheet, your name is
my lord.
Yes.
Only, my lord, I am reading out one statement. Your Lordship, kindly see how, my lord, the petitioners are implicated. Only there is the last scene.
Where is that?
Srimati Basanti, my lord, my learned friend will say Basanti Mahal.
Which page?
No, not page, my lord. That is मोर नाम बासंती महाली आज आपण
CD has come,
मोर कहबा कि जे मो मोर स्वामी बाउंस पत्तिये रे झुड़ी बुणाबुणी करू ଆମେ ପିଇବା ପାଇଁ ମହୁଲି ତିଆରି କରି ଖାଉ ଏବଂ ବିକ୍ରି କରୁ। 18/10/2023 ଦିନ ପ୍ରାୟ 1ଟା ହେବ ନ୍ୟୁ ଜାନିର ଟୁନା ପାତ୍ର ୱିଥ୍ ଦି ଡିସିଜ୍ ମହୁଲି ପିଇବାକୁ ଆସିଥିଲା। ତାପରେ ରାଉତରାପୁରର ମୂଷା ମହାପାତ୍ର, ମହାନ୍ତିପଡ଼ାର କାଳିଆ ଦେହୁରୀ ଦେ ଆର୍ ଦି ପିଟିସନର ମଧ୍ୟ ଆସିଲେ। ସେମାନେ ପିଉଥିବା ସମୟରେ ମହାନ୍ତିପଡ଼ାର ନାଣ୍ଡୁ ପଲେଇ ମଧ୍ୟ ଆସି ମହୁଲି ପିଇଲା। ସେ ଧରିଥିବା ମାଛକୁ ଆମ ଚୁଲିରେ ପୋଡ଼ି ଖାଇଲା ଓ ସେମାନଙ୍କୁ ମଧ୍ୟ ଦେଲା। ନାଣ୍ଡୁ ମହୁଲି ପିଇ ସାରି ଆଗେ ଆଗେ ପଳାଇଗଲା। ଝୁନା ମହୁଲି ପିଇ ସାରି ମୂଷା ଓ କାଳିଆକୁ କିଛି ମହୁଲି ଦେବାକୁ କହିଲା। ସେ ମନା କଲେ ଦେବାକୁ। ଝୁନା ତାର ପାଖରେ ରଖିଥିବା ଗଞ୍ଜେଇକୁ ବାହାର କଲା। ଗଞ୍ଜେଇ ଦେଖି ସେ 2 ଜଣ ଝୁନା ପାତ୍ରକୁ ଗଞ୍ଜେଇ ମାଗିଲେ। ସେମାନେ ପାଟିତୁଣ୍ଡ ଲାଗିବାରୁ ମୁଁ ସେମାନଙ୍କୁ ସେଠାରୁ ପଳାଇ ଯିବାକୁ କହିଲି। ମୋର ସ୍ୱାମୀ ସେଠାରେ ପାଛିଆ ବୁଣାବୁଣି କରୁଥିଲେ। ମୂଷା ଓ କାଳିଆ ଆମ ଘରୁ ପଳାଇ ଗଲେ। ଦେ ଆର୍ ଫାଷ୍ଟ went from the house of the ତାଙ୍କ ପଛେ ମାଇ ଲର୍ଡ ତାଙ୍କ ପଛେ ପଛେ ଝୁନା ପାତ୍ର ମଧ୍ୟ ଗଲା। ସେମାନେ ଗାଁ ରାସ୍ତାର ନଦୀ ଆଡକୁ ଗଲେ। ଗଲା ସମୟରେ ପାଟିତୁଣ୍ଡ ହୋଇ ଯାଉଥିଲେ। କହିଁ ପରଦିନ ଜାଣିଲି ଝୁନା ପାତ୍ର ତୋଟା ଭିତରେ ମରି ପଡିଛି। This is the statement of the
last scene.
Last is under 27 and reading to discovery of
and
Evidence Act recorded.
the
27 Evidence Act, their statement recorded manner. And that about 3 of the witnesses manner they have stated in their 164 statement manner. Manner one Guruvar Soren. I read out the relevant person. ଆଜକୁ 4 ମାସ ହେବ ଦିନ 1ଟା ସମୟରେ ଝୁନା ପାତ୍ର ଡିସିଜ୍ ମୋ ଘରକୁ ଆସିଥିଲା ମହୁଲି ମଦ ପିଇବା ପାଇଁ। ମୋ ପାଖରେ କିଛି ମହୁଲି ମଦ ଥାଏ। ଏହି ସମୟରେ ମୂଷା ଆଉ କାଳିଆ ଦେହୁରୀ ଆସି ମୋ ଘର ବାରଣ୍ଡାରେ ବସି ମଦ ପିଆ ପିଇ କଲେ। ସେହି ସମୟରେ ଝୁନା ପାତ୍ର ତା ଅଣ୍ଟିରୁ ଗଞ୍ଜେଇ ବାହାର କରି ଧରିଲା। ତାକୁ ମୂଷା ଆଉ କାଳିଆ ଦେହୁରୀ ଗଞ୍ଜେଇ ମାଗିଲେ ଟାଣିବା ପାଇଁ, କିନ୍ତୁ ଝୁନା ପାତ୍ର ତାକୁ ଗଞ୍ଜେଇ ଦେଲେ ନାହିଁ। ସେଥିପାଇଁ ତାଙ୍କ ମଧ୍ୟରେ ଝଗଡ଼ା ହେଲା। ଏ ଦେଖି ମୁଁ ତାକୁ ମୋ ବାରଣ୍ଡାରୁ ଚାଲିଯିବା ପାଇଁ କହିଲି। ସେମାନେ 3 ଜଣ ସେଠୁ ଉଠିକିରି ନଦୀ ଆଡ଼େ ଚାଲି ଚାଲି ଗଲେ। କାଳିଆ ଦେହୁରୀ ଟୁନା ପାତ୍ରକୁ ଡାକି ନେଇ ପଳେଇଲେ। ତା ପରଦିନ ସକାଳୁ ନାଥ ମଲ୍ଲିକ ଆସି ଗାଁରେ ଝୁନା ପାତ୍ର ଗାଁ ତୋଟା ପାଖରେ ମରି ପଡ଼ିଛି।
Strong circumstance.
Strong circumstance.
Only
the time gap, my lord, the evening.
There is time gap and
You are in custody since?
my lord, your lordship, another my lord.
Custody, you tell me.
My lord, I am telling you.
Custody period.
My lord, custody. I am saying my lord. Custody, my lord, on 22/10/23. 22/10/23.
What is the stage now?
Stage, my lord.
Charge sheet filed, my lord.
Charge sheet filed.
And another my lord, another statement ସେ କହୁଛନ୍ତି ସେ ଉପର ବେଳା ତୋଟାରେ ହାତୀ ଭୟରେ ତୋଟାକୁ କେହି ଯାଆନ୍ତି ନାହିଁ। ଯୋଉଠି ଡିସିଜ୍ ମଲା ସେଠି କେହି ଯାଆନ୍ତି ନାହିଁ ହାତୀ ଭୟରେ।
Another 2 statements, my lord. 164.
Statements are there direct.
ନାଥ ମାହାଲି
Not direct
relevant
statement.
person
They are the
ସେମାନେ ମଦ ପିଇ ଆସିଥିଲେ ଆଉ ମୋତେ ଝୁନା କହୁଥାଏ ଡିସିଜ୍ ମୁଁ ମୂଷା ଆଉ କାଳିଆକୁ ନଦୀ ପାର କରେଇ ଦେଇ ଆସୁଛି। ଏହା କହି ସେ 3 ଜଣ ନଦୀ ଆଡକୁ ଗଲେ। ପରଦିନ 19 ତାରିଖ ଦିନ ଆମେ ଝାଡା ଫେରି ଯାଉଥିଲୁ ନଦୀ ଆଡକୁ। ସେଠୁ ଆମେ ଦେଖିଲୁ ଯେ ଝୁନାର ସେଇ ପାଖରେ ମରି ପଡିଛି।
These are strong circumstances what to do.
Another witness also stated.
Only on the last scene, my lord. There and
Circumstances don't tell the lie. Witnesses tell lie.
The gap between the recovery dead body last scene, no so long, my lord, so that one can third person and come and
on the very next day,
let these witnesses be examined.
My lord.
The next day, my lord, the dead body recovered.
Charge sheet has been filed.
Filed.
And these people were shown as witnesses or not?
My lord.
Just see, you have shown in the 164 statement.
164 statement.
How many
their name, my lord?
The statement of how many people you have recorded? 164.
Three, my lord.
3 of them.
Guruvar,
these 3 we examined.
Guruvar Soren, Nath Mahali, and another Nandu Pallei.
Petition is agreed by the order dated. Don't write.
14/11/2023.
Whereby his bail plea has been rejected. Bail plea. This is a case based on only circumstantial evidence. The last scene theory is cited against the petitioner, apart from the fact that there was discovery leading to disclosure leading to discovery.
Under Section 27 evidence.
Section 27 of evidence. Evidence. The prosecution had examined 3 witnesses under Section 164 CRPC. They are namely
Guruba Soren, Anandra Malana, Nath Mahali, another Nandu Pallai.
Nandu. All three of them has supported the prosecution regarding the fact that the petitioners were class C with the deceased, and there was a fight between petitioner and the deceased. Therefore, I am not inclined to grant the petitioners the concession of bail at this stage. However, I am of the view that the petitioner shall renew the bail plea after the examination of the three witnesses, those who have been examined, those who have been examined under section 164 CRPC. It full stop. Since the petitioner is in custody since
23/10, 22/10/2023.
23, so it is expected that the prosecution should do well to see that the evidence of these three witnesses, above mentioned three witnesses, are examined preferentially, examined in the
First instance.
Examined first, examined first. Examine first with this observation.
No.
You examine these three witnesses first. Thereafter, she will tell you. If these three witnesses goes, then he is out. Yes.
25.
On behalf of Mr. Cham, I prefer a passover, my lord.
Passover, okay.
26.
Yes.
Not that my mother I pay for interim bail matter. My mother was serious. I have the only son.
Have you filed any document?
How medical certificate I filed?
Okay. Where is that?
I know.
Where is that?
891/2024.
Have you got the
Flag C.
Huh?
Flag C.
Have you got the instruction?
No, my lord.
Right, and issue notice on IA number so and so. Or counsel for the petitioner submit that the petitioner is the only son, and his mother is
85 years old.
terminally ill. Therefore, he seeks interim bail. Let the state council verify the authenticity of medical document placed on record, at least after 1 week. Yes. Next.
27.
Yes.
Well, item 27, on the self-same affair, another 4 bail application, let it come along with these 4 bail applications on the self-same affair.
No, I didn't follow.
On the self-same affair, my lord, for on other my lord, bail application for the other accused have been filed, let it come along with all these.
4 accused, what happened? 4 accused.
Say pending, you see.
Pending.
Can be listed, my lord, along with the.
Give the numbers.
Yes, my lord, I am
List
giving
this,
the number.
with the pending application of co-accused persons.
Yes, my lord. I am giving the number.
28. I know, let it come. At a time we'll reject everything.
Sub confessional statement.
May I pray? In this case, my lord, the petitioner arrested on 16/5/2023, offense under section 20B IIC of the NDPS Act.
What is the recovery?
Recovery, my lord,
52 kg.
52 kg. 3 persons are there, my lord, in a Tata Sumo car.
What is your role?
I am the driver, my lord, in this car. So other 2 is juvenile, my lord. They are in custody, judicial custody, and one is bail, my lord, annex 3, my lord. Kindly see the co-accused.
Whose car was this?
Driver, my lord.
You are driver, I know. Is it your car?
No, this is mine, not my car.
Whose car is
the driver? Owner of the, my lord, owner is Birju Kumar. Oh, the owner, my lord.
Okay.
I am the driving the car. I am the driver.
Either he has annexed the FIR.
Only has kindly see the rejection order, my lord.
Rejection is all right. On the basis of rejection order, I can't decide everything.
The FIR is not, my lord. 3 persons are there. 2 is juvenile. And another, the present prisoner is adult, my lord. So separate, he is.
Where from I will get all these things? From your record which you have filed.
That is
Don't
the
file anything.
Annex 2, my lord, the rejection order.
So to only rejection order that
Yes.
from the Tata Sumo Gonja was seized. So from his conscious possession Gonja was.
What is the stage?
Stage, my lord,
And stage
here
is
submitted.
posted to 17/8/24 for evidence. Evidence is now
Evidence.
going up.
Evidence is going on.
Right. And this is rejection order of the year.
Independent witnesses are there?
No, my lord.
Well, if he has not annexed the FIR, how could I know that who are the?
The whole difficult
Not
right now.
necessary,
The petitioner is accused and substance. The bail plea of the petitioner was rejected on 12/12/2020.
Yes, sir.
Land Council of the state submits that the trial is scheduled to commence from
Posted to 17/8/24
17/8/24
for evidence.
After the independent witnesses are examined, the petitioner is granted liberty to renew the bail plea. Renew the bail plea. At this stage, I am not inclined to enter this petition because the bail application of the petitioner was rejected on 12/12/2023, and thereafter charges were framed, and the trial is set for recording of prosecution evidence. Prosecution evidence. With this observation, the petition is dismissed. Yes. 29.
In this case, the petitioner is the husband of the deceased wife. Husband of the deceased wife is in custody since 14th April 2023.
23. April 23. Yes.
Initially, the affair was lost against the husband under the section 490.
You are the husband.
Husband.
Okay.
The marriage was solemnized in the year 2018. After 15 years of the marriage, the incident was occurred when the petitioner
302 or 304B?
304B has been deleted in charge sheet. Now the petitioner is facing 498 30 of IPC.
302.
302. My lord. The allegation in the bottom of the affair that ଆଜି ସକାଳ 8 ଘଟିକା ସମୟରେ ଭିଣୋଇ ଫୋନ କଲା ଯେ ତୁମ ଭଉଣୀର ଅବସ୍ଥା ଖରାପ ଅଛି, ଶୀଘ୍ର ମେଡିକାଲ ଆସି ମୁଁ ଆସି ଦେଖିଲି ଯେ ଗତକାଲି ରାତିରେ ଭିଣୋଇ ଭଉଣୀକୁ ବିଷ ପିଆଇ ଦେଇ ଭଉଣୀର ମଥାକୁ ପିଟି ଫଟାଇ ଦେଇଛନ୍ତି। ତାପରେ ମେଡିକାଲ ଆଜି ଆଣନ୍ତି, ଡାକ୍ତର ମୋର ଭଉଣୀକୁ ମୃତ ଘୋଷଣା କଲା ପରେ ମୁଁ ଆସି ଆପଣଙ୍କ ଗୋଚରାର୍ଥରେ ଜଣାଇଲି, ଏହାର ତଦନ୍ତ କରି କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ଗ୍ରହଣ କର। The allegation in the affair that ତା ପୂର୍ବ ଦିନ ରାତିରେ ମୁଣ୍ଡ ଫଟେଇ ଦେଇଛନ୍ତି ଆଉ ବିଷ ପିଆଇ ଦେଇଛନ୍ତି। This is the allegation. So far the inquest report prepared in the investigation process I have filed, there is no external page 13 annexure 3. Again, column number 5, apparent injuries or marks on the body. ମୁତଫିକୁ ସାକ୍ଷୀ ମାନଙ୍କ ସାମ୍ନାରେ ଓଲଟପାଲଟ କରି ଦେଖାଯାଏ ମୁତଫି ଶରୀରରେ କୌଣସି କ୍ଷତ ଚିହ୍ନ ପାଇଗଲାନି। ତ ସେ ଯୋଉ ମୁଣ୍ଡ ଫଟେଇ ଦେଇଛନ୍ତି, that is a bald allegation.
What about poisoning?
Poisoning, my lord. Poisoning, my lord. Cause of death, viscera ଯାଇଛି, viscera report outing କରି preliminary charge sheet submitted. So this statement of
report.
My lord, viscera report was outed because when rejection,
it is in the medical report, it is written cause of death of the disease is not known.
My lord, in the PM report also stated that death could not be ascertained due to
my lord. So far
the outing viscera report
again,
and the rejection order is
you repeat renew your.
I am coming, my lord. The statement of independent witness କହୁଛନ୍ତି ତାଙ୍କର statement police collection କରିଛି, ସିଏ ବିଷ ପିଇ ଦେଇ ମରିଛି। 4 witnesses said the
so all these things the
the administration of that is to be decided in the trial.
See viscera report whether death is because of poison or
the
because
death of poison, assuming the death of poison 302 ହବ ଯଦି ମୁଁ ବିଷ ପିଆଇ ଦେଇଛି, ତାଙ୍କ ୱିଟନେସ୍ ମାନେ କହିଛନ୍ତି ସେ ବିଷ ପିଇ ଦେଇଛି। ମାନେ ୱିଟନେସ୍ ଅରୁଣ କୁମାର ସିଂ ଗତକାଲି ଘଟଣା ବିଷୟରେ ବୁଝାବୁଝି କରିବା ଜାଣିବାକୁ ପାଇଲି ଯେ
who is he?
The independent witness
Who is he? Was he there?
ମାନେ
Has he seen that disease was drinking?
How
who is he?
They collected and
Who is he to tell what is happening in their house?
Villagers, my lord.
Villagers
our statement have used.
Villagers have seen that he was taking poison. What kind of witnesses are there?
This is the investigation report, my lord. They have collected investigation.
These no relevancy of these witnesses at all. Inside the house something happened. She consumed poison or poison is administered, nobody knows it. And a villager who is nothing to do with the family, he was not anywhere, He says that, no, I have seen.
ତାଙ୍କର statement first part ଯୋଉ କହିଲେ ମତେ ମାରି ଯଦି ମୁଁ ସ୍ତ୍ରୀ କି ମାରି ସେଇଟା appears to be
There you are correct.
ବର୍ଷେ
Villagers, my lord, stated that there is physical torture and also. My lord, it was.
No. That is also incorrect submission. ସେ previous 15 ବର୍ଷ ପରେ ବାହାଘର ପରେ incident
This final charge sheet you have filed.
My lord, only preliminary charge sheet was filed awaiting visceral report. My lord, and now the stage is, my lord, that trial.
Petitioner is agreed by the order dated
21/9/23.
21/9/23. In the present case, petitioner is agreed. In the present case, preliminary report has been, preliminary charge sheet has been filed by the police. Awaiting the viscera report, the final charge sheet has not yet been filed. Therefore, I'm not inclined to enlarge the petitioner on bail at this stage. However, the liberty is granted to the petitioner to renew the bail plea after the final charge sheet is filed. If such application is moved before the trial court, the same shall be considered on it.
মানে ফাইনাল চার্জ শিট ସେମାନେ ଆଜି ଯେ ଫାଇଲ କଲେ ସେ ଯେ ଏଇଟା କଣ୍ଟିନ୍ୟୁ କଲେ ମାନେ
I'll indicate that.
ସେଇଟା ରେକର୍ଡ ପ୍ରଡ୍ୟୁସ କରିବାକୁ 6 ଥର ଲାଗିଗଲା.
Submits that the police is unnecessarily delaying in filing the final charge sheet. Awaiting the final charge sheet, the petitioner cannot be put to prejudice. In that view of the matter, and at this stage, Mr. Counsel for the state submits that he would pass on the instruction to the investigating agency to see that the charge sheet is filed as expeditiously as possible. If the charge sheet is final charge sheet is not filed within 3 months hence, the petitioner has the liberty to renew his bail application before the trial court, and the trial court shall consider the bail application on its merit on the basis of the preliminary charge sheet, even on the basis of preliminary charge sheet. 3 months you filed the final charge sheet.
My lord, what instruction, my lord, that the charge was framed on 29/1/2024. And it was posted to 6/8/2024.
You people are not sure what you are saying. I don't see whatever you say.
ସେମାନେ କହୁଛନ୍ତି
Why
ଫାଇନାଲ
are you giving misleading statements? I don't.
My lord, he has to better known that what is the stage of
you are better person, you are saying the charge.
But what I have collected, that charge was framed on 21/9/2024.
Government has the record. ମତେ ନେଇ ଭିତରେ ପୁରେଇବ, ମତେ ପଚାରିବ ତୁ ମତେ କହିବ ମତେ ନେଇ ଭିତରେ ପୁରେଇ ମୋରି ଉପରେ ନଦା
fall to this is that is
ଖୁସିରେ ଭିତରେ
the impugn order
ଖୁସିରେ ପୁରା ଭୁଲେ ପୁରା ପୁରେଇ ସାରିକି ମିଛ
the
କଥା.
trial court has rejected the bail application of the petitioner on service charge. Meanwhile, let the counsel for the state submit that meanwhile the charge sheet has been charge has already been framed. The petitioner may renew the bail plea of bail plea after the examination of the
material witnesses.
Informant.
Material witnesses. Material witnesses.
ପୁଣି ତମ ୱିଟନେସ୍ କିଏ ମେଟେରିଆଲ କିଏ ଜଣାବ?
How?
ବଢିଆ କଥା କହୁଛ ତ.
My lord,
Who is the informant?
ତମର କୋଉ
but some of the villagers and complainant, they have stated.
Villager, lead the villager, family member.
My
of
lord,
the deceased.
complainant is, my lord,
Family member of
that Chakradhara son, Chandrakanta Sandha, my lord.
family member of the. I expect that
Brother,
at least-
my lord.
I expect that at least you people should give effective assistance so that we can dispose it up. In
My
the
lord,
bail
we-
matters, 12:30, 16 matters is only over. What kind of assistance you are giving? I was thinking of listing 100 matters so that there will be no complaint. And this is the level
My
of
lord,
assistance.
my lord,
I give a full order spending 10 minutes, thereafter you say that everything.
No, my lord, I have collected from the website, my lord, that charge was from, but he has to better note that what is the
Yes,
stage
next,
of the.
next, next,
ସବୁ
next.
ତ ଆମେ ଜାଣିବ ତୁମେ ଆଉ କଣ କରିବ?
30. Yes. 30. Who is there? What is this? This matter?
My lord, 376(3) is there, my lord.
376, 3.
3, my lord. Someone has appeared.
Who was there earlier?
Or someone appeared on behalf
Pass
of the
over,
informant.
pass over. Yes, next.
31. My lord, 31 kindly taken up one chapter.
What is this matter? It's pending since 2020.
My lord,
What is this?
The arguing counsel is suffering viral fever.
Okay, that is also 3763.
This is bail application.
Yes, my lord.
So next week, he's suffering from viral fever. Yes. Next.
My lord, 32, my lord, he has to file surrender certificate, my lord.
Yes, sir.
The
Interim
noting
bail
is
was
also there.
granted to you.
My lord, in this matter, the client has already taken the file. So our names,
After interim bail, you were supposed to surrender when?
no, we just wanted to delete our name from the list
No, it's
because
all
he,
right, but when the interim order was given?
Order dated, my lord, 27/6/24.
26?
27/6/24.
27/6/24. Yes. For how many days it was given? When the interim order?
Well, that is 27/6/24. my lord.
That's right. Expire when?
Interim bail granted.
Four weeks. 27.
6.
By the order dated 27/6/2024, this court had enlarged the petitioner on interim bail for 4 weeks. The surrender certificate has not yet been surrendered, has been filed. Learned counsel appearing for the petitioner seeks discharge from this case. None appears for the petitioner. None appears for the petitioner. Leave the matter next week. Otherwise, we'll dismiss. Yes.
33.
Yes.
Item number 33, my lord.
Yes, sir.
My lord, it is a case. My lord, may kindly have a look to order dated 23/7/2023, 2024, my lord.
23/7/2024,
my lord. The last order, my lord Justice A.K. Mahapatra passed, my lord. Here in this case, my lord.
High Court.
My lord.
Don't take the name of the judge. Yes.
23/7.
But the state is directed to seek instruction from the IO with
My
regard to the involvement of the present petitioner and also obtain instruction as to whether the corroborative material available with regard to the allegation made against the petitioner.
Yes, my lord.
Yes.
Here in this case, my lord, the petitioners both are the husband and wife, my lord. They are in custody since 21/5/2023.
Right.
Allegation against them, my lord, 420, 406, 294, 506, and 34 application, my lord. It is the allegation against them, my lord. So far as the allegation of the prosecution case is concerned, my lord, it is alleged that one SSG group consisting of 14 members, Porjayakromme, they have given 2 crores of money to the present petitioners, my lord, for investment. And the present petitioner.
How much?
2 crores, my lord.
2 crores.
It is their allegation. Porjayakromme, in the first line, Bhabyamanakotaru, Indumati Patnara, Ajay Kumar Rao, the present petitioner, Ammanakaru, Porjayakromme, ବିଭିନ୍ନ କାର୍ଯ୍ୟ କରିବା ନିମନ୍ତେ ଆମ୍ଭ ମହିଳା ମାନଙ୍କର ସହିତ ମିଶି ବିଭିନ୍ନ ପ୍ରଲୋଭନ ଦେଖାଇ ଆମ୍ଭମାନଙ୍କ ଠାରୁ ପ୍ରାୟ 2 କୋଟି ଟଙ୍କା ନେଇଗଲେ. So after completion of investigation, charge sheet is submitted where it is stated that 1,84,000. It is the
They say roughly 2 crores and 184.
1 crore 84 lakhs.
So far as the case is concerned, my lord, basing on the statement of the witnesses, 406 is, my lord, charge sheeted under section 406, my lord. Save and accept the statement. There is no item of evidence
That's enough.
against the present petitioners, my lord. So far as this 406 is concerned.
How many victims in this case?
My lord, there are
SSG group members or total members, sir?
Total members, how many? Many members you might have cheated.
Only 14 members, my lord, in the
Only
FIR.
14 members is enough.
Yes.
See, page 13. Page 13, how many people are signed?
My lord, they have signed in the FIR, my lord, only 14 members.
Only.
They are the SSG groups, my lord. fact remains, my lord, their transaction was going on since 2010, my lord.
See, had it been a case of a small amount, I would have entered you on bail. Because the huge amount is very huge.
My lord,
rejection order, my lord, and
my lord, it
page
is a
8, my lord.
huge amount, I do admit, but only basing on the statement, my lord.
What else you need?
Need, my lord, there must be a agreement between themselves.
Not necessary.
My lord, it is
SSG group, villagers, you have taken money. What agreement?
my
What,
lord, kindly say that SSG group.
innocent people are cheated like this only.
No, my lord.
And wife and husband.
It is
And it was
cheating, my lord.
transaction was made through UPI, my lord. Kindly see page rejection.
My lord, UPI रे ये transaction करछि किंतु जो माने informant group से माने UPI रे payment किछ देई ना. That's why
what are you doing for living? You tell me.
My lord,
what are you doing for your living?
SSG group रू पैसा नहीं investment करे
then
market
how
रे.
UPI the amount being transacted, where from you got the money?
Yes,
you are
that
having
amount.
independent income.
No, my lord. That amount I got from the SSG group. My role is that, my lord. मोरो SSG group रू पैसा नहीं है ताको investment करे market रे जहाँ interest पाए तांको 7% दिए मु 3% पाए interest पाए मु सेतरे चले. ए कोरोना समय रे जो मार्केट रे इन्वेस्टमेंट करते किछि पैसा से पैसा आउ कोरोना परे आउ मिलिलानी तेणु पिटिशन नंबर 2 विष खाई देला एवं लकीली सी एक्सेप्ट माय लॉर्ड एस्केप्ड माय लॉर्ड इन द चार्ज शीट माय लॉर्ड इट इज क्लियरली स्टेटेड दैट शी कंज्यूम्ड पॉइजन माय लॉर्ड व्हेन द एसएसजी ग्रुप मेंबर raised holla and went to the house of the present petitioners and threatened to do away with their life, my lord. And the petitioner number 2,
Yes.
my lord,
What is the case?
Stage I have not obtained, my lord.
Huh?
The status
Investigation is complete, charge sheet is filed.
Well, preliminary charge sheet was filed.
And then what about final charge sheet? Or the same story? I'll dictate the order, then you will say that.
No, well, in that case, my lord, I have obtained instruction
But
from the website.
Here you tell me whether what is the stage?
My lord, strategy trial is going on.
Preliminary charge sheet is saying.
No, my lord, preliminary charge sheet is submitted. What preliminary?
But what record, my lord, in that time we have collected
submitted
record.
that investigation is
I
open under
told you
section
the other day,
173(8), my
see,
lord.
these matters are pending since years, 2 years and all, bail matter. Without waiting for the court to ask you, please get the information. Be ready with that. On the stage of
My lord, actually what
True, my
happened?
lord. You are also saying that true, my lord. But in fact, my lord, yesterday night you have received the file, my lord. Some cases you have got instruction is there, my lord, and some cases court call for the report from trial court. Some cases, my lord, I have to take instruction 1 week by time given for that.
My lord, we are getting file at
And
11.
in this case, you get instruction. I will put it next week.
Well,
But what is worry, I tell you.
My lord,
See, these are the
pending
matters
70
pending,
occurrence, my lord.
pending
That-
to 23, 22.
my lord.
And we are not able to dispose of bail application in 1 year.
My lord, at that time we have received the case diary. In the case diary, preliminary charge sheet was there. Now it was listed.
But you have to be little proactive. That's what
There are some.
suggestion is.
In 11 PM, we have receiving that files, my lord. And
I know you have your own problems. I understand that. But
My-
still you try to be little proactive so that we can.
My respectful submission before your lordship that save and accept the 161 statement. There is no other evidence.
That is enough, sir, in these kind of cases.
My lord, so far as four.
Get this.
But this
my
problem
lord, he is saying that trial is going on. He has been the status that trial is going on.
You also seek how many witnesses
After
are
one
there?
date,
What
or-
how all these things.
This will not repeat, my lord, since one order.
Ah.
Thereafter, everything will okay, my
You
lord.
get instruction how many witnesses are there, how much time it will take, and all these things. So that overall situation we'll see and we'll entertain. Yes, next
Next week, my lord.
next week. Yes.
My lord, date may kindly.
Date will be given. Don't worry.
Obliging.
You'll get it. Yes. Yes.
May it please, your lordship.
Yes, madam.
Your lordship, the present petitioner is in custody since 1/2/2023, your lordship.
Hmm.
Initially, FIR was registered under section 376(2)(n), 6 and 17 of the POCSO Act, 25-27 of the Arms Act, your lordship. Subsequently, the charge sheet has been submitted only under 376(2)(n) and 6 of POCSO Act.
But then in that case, you have to implead the.
Your lordship, since 376(2)(n) is there, so that is why we have not impleted the
It's not
inform.
necessary?
No, Your Lordship, that is it.
Okay.
Your Lordship, the allegation against me in the FIR is heinous allegations, Your Lordship. But subsequently, the allegations were not found to be true. That is why even 506 was not added to the offense of 376, Your Lordship. Allegation against me is that I have taken away the victim and I have kept the victim along with me, and subsequently the victim I have had assaulted her sexually, and thereafter she has come back to her home and lodged an FIR, Your Lordship. That is the allegation, Your Lordship. However, Your Lordship, the occurrence is of the year 2022.
164 statement.
Your Lordship, once that is what is my contention. Whatever she has alleged against me in the FIR 164, she has stated nothing except the fact that I had taken her from her home. Your
What is
Lordship.
the stage?
The stage of the case is also that the victim is being called for examination. Your Lordship may look into the previous orders. Even in the trial, she is not coming even to depose against me, Your Lordship. That is why a warrant has also been issued against her. So my contention is that, Your Lordship, for 7 months, there was no missing report lodged by her parents, Your Lordship. Even if it is a case that I have kidnapped the victim, no missing report was lodged against me, Your Lordship. And subsequently, the father of the victim has lodged an FIR, Your Lordship. So for this, my only act remains that I've married a minor, Your Lordship. The FIR allegations are very heinous in nature, Your Lordship.
Bail, you are not able to examine the victim because the last order says that in such view of the matter, steps be taken in the meantime for examination of the victim. The present bail application of the petitioner shall be considered after the examination of the victim. Have you examined the victim?
She's not coming for examination only.
But
Does
what
the-
I have gathered the instruction from the website, my lord, that was posted for framing of charge. But he's saying that
Last order says that father is examined, mother is examined, father is not coming, summons are issued, not coming, victim is also not coming. So
that is
therefore
order-
the court said that wait till the victim is examined.
that order dated 16/10/23.
No, 22/4 to 24. 3 months over.
34.
34 annexed to 2, my lord, that is order dated 16/10/23.
No,
That is-
22. In this case, order. In this
That order-
case, order was passed on 22/4/2024. It must be there in the website.
It is there in the web.
Last order you should have seen. This is the last order. He says that the victim is not examined.
That instruction I will take, my lord, whether victim was examined or not, my lord. All right, it is difficult, but when to whom we will make phone call, my lord, to the PP, whether he will verify the record. In the morning there is court in 10:30. So
You
all these
may-
instructions,
The problem is you may have 1001 difficulty. Difficulties are there.
my lord.
But you must not forget one thing, that you are prosecuting them. They are in custody.
That's
Your
correct, my lord.
difficulty should not infringe their right to liberty.
Yes, my lord.
You may have 1000 difficulties.
Well,
The system is like that. What
Well,
to do?
actually, practically it is not possible because in the night, to whom we will take
I am
instruction, what
telling
is the
you, because I was also that side.
My lord, I know
I
that.
know what kind of
What-
a problem, but in the same time, if this kind of situation happens, we have to grant bail.
My lord, if your lordship, my lord, in this case, if your lordship will give some time that to take
I'm
instruction on
putting it
such
next
matter.
week. Next week you tell me, otherwise I will have to.
Yes, my lord, if your lordship will grant me
Because
time, that I will-
this court has already repeatedly said that please examine the victim. See, 2-3 orders you have not done, so therefore 1 more week. To say, in compliance to the order dated 21/2/2024 and 22/4/2024, the Learned Council for the State should seek instruction, leave the matter.
My lord, one request, my lord, if your lordship will list these matters in a weekly list. Suppose in the Procedural these matters will be listed. In the meantime, we
Then
can.
we have the regular matter in weekly list. So
My
that
lord,
will
what
be-
happened? In the meantime, we can take instruction. If we will get time, that weekly list, it will be listed.
I will give one week thereafter, so
My
that's no
lord.
problem. 1
Yes,
week
yes.
I'll give. I'm giving 1 week in this matter. In all the matters, I'll give 1 more week. You
that
get
in the
instruction,
meantime, we will
otherwise
take
you'll decide.
instruction. Yes, yes, ma'am.
35.
Yes.
May I please, my lord? Your lord, the petitioner is the husband and
Yes.
is inside the custody since 38/2023, my lord.
20?
23. Series
October 23.
October 23, my lord. No, initially the case was registered under 302, 304B.
Yes.
And
What are the allegations?
Yeah, my lord. Now, my lord, charge sheet has been submitted under 306 and 304B, my lord. Allegation, my lord.
You are the husband.
No, my lord. The
You are the
husband.
husband.
Yes, my lord.
An incident took place
Allegation is
within
that
2
my-
months. Within 2 months, incident took place.
Yes,
Marriage
the
was-
suicide, the police has recovered the suicide. Last occasion,
Who is the informant?
informant is the brother of the deceased, my lord. No, my lord, case
Charge
is
has
that, my
been,
lord.
charge has been framed.
My lord,
Trial is going on.
material witness have been examined. I have filed the depositions copies, my lord.
Examined.
Yes, my lord. I have
No,
filed the copy of the
yes.
depositions.
My lord, PW3 is the informant.
Then what does he say?
My lord, here, my lord, their allegation is that, my lord, the present petitioner was not happy with the dowry articles. That is the allegation. The petitioner also not happy with the color of the victim.
Show me the relevant part.
Relevant part, my lord.
Para 2, my lord. That PWT, PW3, my lord, who is the informant.
What is his role? This thing.
PW3, my lord.
All are stated that there is
Is the brother
How he died?
died, my lord, is
Hanging.
hanging, my lord.
by the suicidal hanging.
Fact, my lord, the neighbors also said that the petitioner was not happy with the black complex of the victim, my lord. And for that reason, there was she was not happy and committed suicide.
How many witnesses are there?
Material witnesses have already been examined, my lord. Means the relatives of the victim, my lord, they have already examined.
My lord, there
And
is
it's the case of
29 witnesses, my lord.
and it's case of
And
306.
all
my
are,
lord.
my lord, stated that there is torture and demanding of dowry. And within 2 months of marriage, she
Torture
has committed
allegation kichi nahi. There is no allegation of torture.
Alright, he will be convicted, but 306.
304B, 498,
No,
306.
306 only.
No, my lord, charge sheet submitted on 304B.
No, charge frame under 30.
306, my lord,
No,
304B.
304B or 306.
306 as well as 304B.
304B, 498.
Mal.
304B is there.
Yes, my lord.
304B.
306 is there.
306 obviously would
Mal.
be there. Obviously would be there.
And there is suicidal note was also, my lord, seized.
How many witnesses you have said? How many witnesses are there?
29 they are
29.
saying, and material witnesses have already been examined, my
Alright,
lord.
29, na? 29.
My lord. And my lord, my submission is well, material witnesses have already been examined, my lord.
Examined on 13th June 24. Okay. Where is your rejection of?
Rejection was prior to that, my lord.
Then you have to go to the court of first instance.
My lord,
Right
subsequent.
away. The
This
impugn of-
case,
where the petitioner is accused in such and such case. The bail plea of the petitioner was turned down by the trial court on 22/12/2023. After the rejection of the bail plea of the petitioner, the trial court has the prosecution led the evidence, and the trial court has recorded the statement of evidence of all the material witnesses, namely PW1 to PW6. PW6. Trial is proceeding at the expected pace. Since the evidence of all material witnesses have already been examined, subsequent to the passing of the impugn order rejecting the bail plea, it would be appropriate for the petitioner to renew the bail plea before the trial court. If such application is moved, the trial court should decide the bail plea on this basis of the evidence available on record, evidence which has already come on record. With this observation, the petition is.
my lord, 1 year already passed. She is inside the custody for 1 year. Again, my lord, the trial court will not turn again. Again, I have to come, my lord. Your lordship may consider, my lord, here, my lord.
No, court of
I have
first
already filed the depositions,
court of
my lord.
first instance should do it. You do be positive. Yes. Next.
36.
Yes. 36. Offense.
My lord, 3763, 6 POSCO, 3 SC/ST. And my lord, noting is that service return of notice issued to the petitioner through superintendent of district jail.
Petitioner?
No, petitioner, notice petitioner, my lord. So superintendent of jail, Bolangir is not yet returned.
This is filed by whom?
My lord,
some lawyer.
It will be to the informant, my lord.
Why
Wrongly
not this was
perhaps.
issued to an
But the
informant,
3 SC
maybe
is there.
informant, none appear for the petitioner, and the matter is called. None appear for the petitioner. Petitioner is not appearing at all.
For that, it perhaps this court matter is notice to the petitioner who is in jail custody to engage some counsel. For that reason, perhaps.
No, nothing is there. If you application. Nobody appears how many times?
Since custody for that, this on the court feels that might be.
That's right,
yes,
right.
correct.
The petitioner is accused in such and such case. The petitioner is agreed by the order dated. Where is that?
16/12/23.
16/12/2023. Whereby the trial court has rejected the bail plea of the petitioner. There is no representation on behalf of the petitioner. Supporting them, you are out. Then bail will be granted.
Eyewitnesses are there, more than 5.
Whatever the material witnesses, you must see that the material
Yes.
witnesses are examined.
I am appearing for the informant.
I'll add one sentence for you that learned counsel for the petitioner at this stage submits that the prosecution may cause delay in recording the evidence of the material witness. It is expected that the prosecution should ensure that the material witnesses are examined first.
Yes.
Yes.
First. These of first.
Yes.
First. These observations. At least they'll start
That's
with
almost clear.
examining of
Vigilance,
the innocuous witnesses and all. First they'll examine, thereafter you can.
ଅଛନ୍ତି ready ହେଇକି ଆଜ୍ଞା.
38.
Last your lordship directed to obtain the instruction from the IO regarding the authenticity of marriage.
Authenticity of?
Marriage. She is a married lady, my lord.
No, I am appearing for the informant, my lord. As per last order, I was directed to file the affidavit, my lord. Accordingly, I have filed the affidavit, my lord. So IO is directed to obtain the instruction whether the
Kindly have glance to the order.
informant is married or
1/7/2024.
That the informant
Regarding
is
the
married lady and
the report has been called for from the IO.
Fact is seriously disputed with the informant. Interview of the material and concord informant is directed to file the affidavit. Have you filed the affidavit?
Yes, my lord.
What do you have said?
I never married, my lord. I also have the Aadhaar card, my lord. I never married, my
What
lord.
is the offense?
376
Offense, my
2N
lord.
313.
Offense, my lord, 376 2N 313 294 506. A charge sheet submitted
What
on
are they? Have you 164 statement is recorded?
last occasion call for the CD and
Have
a
you
medical
have-
examination report also. So far as the allegations are concerned, my lord,
Do you have that?
arising out of
Are you ready?
Yes, sir.
arising out of
I am passing it over. Let him read.
arising out of a complaint case, my lord.
Passing you. I'll pass it over. Let him be ready with that. Yes. Next. 164 and all you just see. Tell me. Yes. 39.
May I please, my lord, on behalf of Mr. S.K. Devedi, kindly one no capture.
What is this matter?
I am appearing for the informant, my lord. I oppose the bail application. This is a 302 case, and here, my lord, the 20 recovery under 27 Evidence Act was there, and the weapon of the offense was recovered, and charge has been framed. No witness was examined, my lord. And they are also not examined, the witnesses to the seizure under section 27.
Who are the material witnesses?
They are the material witnesses, my lord. The independent witness, there is Gupta Chandra Naik.
Eyewitness is there.
Eyewitness is not there. I'm for the informant. They are, my lord, for petitioners.
Well, I am asking you, but
My lord.
so then why don't you wait till the material witnesses are
Yes.
examined? It is a 302 case.
No witness till date examined, my lord. Charge has been framed and it was put up on, I have the, today I have the instruction, 2/9, it was put up for evidence, my lord. Someone notice has gone.
The by the order dated 2/11/2023, the bail plea application is the good case. The counsel appearing for the informant submit that the after charge is being framed, the trial was set in motion, and for the purpose of evidence of recording of evidence of prosecution witnesses, it was fixed on
2/9. I have the
2/9/2023.
telephonic instruction.
2/9/2023. In view of the fact that the bail plea of the petitioner was rejected on 2/11/2023, and the trial has started. Trial has already commenced. It would be appropriate that the petitioner should renew the bail plea after the recording of the evidence of the material witnesses. At this stage, let counsel for the petitioner submit that the prosecution may cause delay in recording the evidence of the material witnesses. It is expected that the prosecution should ensure that the material witnesses are examined first, instead of examining formal witness. Instead of examining formal witness. With this observation, petition. Next.
Obliged, my lord.
Well, there are two applications.
Both the
Both, my lord.
40.
Arising.
40.
I will hear you.
There are two matters. Your lordship has earlier granted interim bail for 2 months.
The
Hmm.
second application, my client has
First
surrendered the certified copy.
In
Correct.
second one, you got entry.
My
First
client has
application surrender कर certificate आसने आओ
the surrender certificate be
next
accepted.
week.
Surrender certificate in second matter.
Second matter. And
Pursuant to the order dated. So
order dated,
interim bail was granted by this court, and pursuant to the said order, the petitioner has surrendered, and surrender certificate is placed on record, which is यही तो problem है. Here nowadays all these things,
Online.
paperless, yes. What will I do with this one paper? Let counsel for the petitioner.
you'll also may record that, and I will.
Please, he hands up the surrender certificate and undertakes to file the same in the registry. Yeah. Next, yes. What is this now? First item.
First item I already मैंने surrender. Kindly next week also. Any date मैंने.
First item surrender. Both second item surrender. No?
I'm for the second item. I have surrendered and certified copy.
You are in the first item.
First item.
For
I'm
petitioner.
ready with my application because nothing has been seized from my possession.
What is the offense?
Offense NDPS. I have been recovery from the first person in December 2022. I was arrested in December 2023. Now the charge sheet I have filed saying that they were procuring. So that bar of the concept possession is not attracted against me.
Recovery how much?
Recovery 102 kg, but 102 kg from his house.
Yes, sir.
How I am
Conscious position is not there.
So, but in their statements, all those are there. They have confessed the statement that we are collecting from him only.
Who confessed? Co-accused confessed.
Yes.
That can be a basis for confession of
That
co-accused.
basis only these things happen also. Because they are
Confession of co-accused is neither here nor there. What is the material against against him? You tell me. In so far as Mr. Das case is concerned, conscious position is not there admittedly, isn't it? It is the case is the main accused from whose position 100 odd kilo ganja was seized
from his house.
From his house, he had said in his disclosure statement that
Not
procured it from
not
X,
only
Y, Z.
he, one statement for the other person also they have said
Maybe.
the same things that it is a continuous process and each and every day
So
they are
there must
collecting
be
from
some
there.
substance in
It
that
is there.
investigating.
161 statements,
Apart from 161 statement, what do you have?
the same thing they are saying that, let's say I am reading that one,
Who are the witnesses?
Subhas Harijan,
Co-accused. He is also a co-accused.
not all are not co, some other villagers also there, they have also stated so.
What is the antecedent he had?
One incident is there.
One.
Yes.
Of mine.
Yes.
Yeah. That is the problem with you. That is the problem. 161 statement coupled with the fact that
161 and the
whatever one, but
They
see,
say.
And
there
how
is an
can they say?
antecedent. There is an antecedent. You check it.
Antecedent.
Next,
account.
leave
295 is there.
next week.
This is not NDPS, my lord. This
Whatever,
is not NDPS.
Similar case.
No. Similar we know. How other IPC offenses.
Just check it up, sir. He is entitled.
395 is there.
Maybe, but how can you entagle?
NDPS has he involved in NDPS case?
NDPS is not there.
Not there. ମୁଁ ଆଜ୍ଞା ବର୍ଷେ ପରେ ମତେ arrest
What is the evidence that he from him they are procuring? He is getting from where?
From the petitioner number one's house, he is also a seller and he is collecting from there.
Source, his source. Have you investigated?
Charge sheet already filed.
Charge sheet already filed, all those co-accused as well as all the one statement of
reading
the
two lines.
villagers
According to
also,
your case,
they are saying.
According to your case, he is the wholesaler, they are the retailers.
Yes.
Okay. Where from the wholesaler is getting the material? He is the wholesaler. He is the retailer.
Only single line.
You have seen from the retailer's house. But have you got any evidence that he is the guy who is getting material from X place of.
If you want an investment, that will come in the trial also, all these things will come out. No.
Immediately
But here how it will, they will say.
ବର୍ଷେ ପରେ arrest
Put
କରୁଛନ୍ତି।
it next week. He just concentrate in his case.
Okay.
He's entitled for bail and
Yes.
his case
Okay.
is
No, Lordship, keep it to next week. I will
conscious
give all this.
recovery, conscious
Yes.
position.
Yes, Lordship.
Your case is difficult.
ତାଙ୍କ କେସ୍ ବି ଆଜ୍ଞା ହେଇଯାଇପାରେ କାରଣ ସିଜରଟା ହେଇଛି ଆଇଓଙ୍କ ଠାରୁ ମାନେ ଇଏ ତ ଟ୍ରାଏଲ ରେ କଣ ହବ କି ପ୍ରକାର ଇନଭେଷ୍ଟିଗେସନ ମାଇ ଫ୍ରେଣ୍ଡ ମଷ୍ଟ ନଟ୍ ହାଭ ସିନ୍ ଦ୍ୟାଟ୍ ଦେଖୁନାହାନ୍ତି କେମିତି କରିଛି
No, next week.
he will feel handicapped next occasion
Another 5-10 minutes.
41 May.
Yes.
376(1), 498A, 4 POCSO Act. Victim is there as per the direction of this honorable court. Victim is in virtual mode, my lord.
Victim is there.
Sir, myself, Bivutranjan Maharaj.
Are you ready, sir?
Yes.
Huh? I'll take it up at 2 o'clock. Then I'll come. If you people have any problem.
2 o'clock, I have one witness to be cross-examined.
Then I'll put it next week.
No, let's see.
My lord, 40th kindly next week on behalf of Manoranjan Pagwal.
There is another item I have got.
67.
In item 67, my learned friend doesn't have the record, so that may be added.
67 next week. Wherever you have, you really want the instruction in all the bail matters, you please inform court master. It will be listed 1 week after, so that easier. Why should I call?
Yes, sir.
If you don't have instruction, you just tell him that I can put it next week instead of calling every matter. With instruction, if you are ready, then I'll hear it.
In the bail matter, my lord, it was listed in the supplementary list. Supplementary list, my lord.
I know
That is
you
not
have
item.
problem. I'll put it next week.
Next week, so that-
नहीं तो leave 1 week. Good week मुझे छाड़ दियो. तो next week पकड़ दी सुबह. By the time I'll get the instruction. Without instruction, why unnecessary?
Yes.
And because these matters are filed in January, February, and all. By now, what has happened? Whether evidences are recorded or not? What is the stage? All these things you get information so that we can dispose it.
Item 38.
Item 46, Lord.
Next week, 1 week we will give.
That Tuesday,
Tuesday? Okay, no problem.
Item 46, Lord.
42 will come on Tuesday.
Item 46, Lordship, I filed an IA for interim bail on the ground of wife's illness, Lordship. The first time listed.
I will come after lunch.
Only,
I'll come after lunch. Why are you? I'm not.
only instruction to call for. Only
Let us
instruction.
see. That's what I told them. If they have instruction, we will proceed.
এটা ফার্স্ট টাইম আসছে ইনস্ট্রাকশন আসেনি সেইথিলাই কই 46 টা মানে
এটা করা Tuesday রে না।
This petition is pending since 4/10/2022. When the matter was taken up in the last date of hearing, none appeared. Even in the second call, none appears today. It appears the petitioner is not interested to prosecute the present matter. Accordingly, it is dismissed. Yes.
Item 6.
May I please, Yours? Lordship, I have taken instruction that 164 statement cannot be supplied to the petitioner, Your Lordship.
It will not be
That is
supplied.
in sealed cover. So may I pray, Your Lordship, kindly direct to the State Council call for the.
What is the offense?
That is, Your Lordship, 376 and POCSO 6 POCSO Act, and the matter is going to settlement, Your Lordship. And I have annexed that both the parties have filed the affidavit before the trial court.
Evidence has not yet been recorded.
No. So I pray, Your Lordship, kindly direct.
See,
I have, as per Your Lordship's direction, I have submitted the entire charge sheet, Your Lordship. That is.
Have you read that? Have you read my judgment?
Yes.
Huh?
Not coming under that.
No.
They are not married.
That is not married.
Then also not married. Settlement doesn't mean.
No, they,
The idea for these
Yeah.
cases to be passed is if they're married, their life will be settled. So that is the reason.
Your Lordship, may I pray one thing, Your Lordship? Kindly, both the parties will present.
No, maybe both the party present makes no difference. Also is there. I can't help you.
So I will
If
take.
they marry themselves, they'll settle in their life to save their.
I will take instruction.
That is the idea. Idea is that.
Yes.
Because young people, they got involved and they are married. There is a child. In all these situations taken.
Yes.
Not that you rape someone and thereafter you pay some money and
No, that I
these are not. These are offences against the state,
Yes.
against the society.
That I understand, Your Lordship. So I will take instruction regarding
What
that.
instruction? There is no
If,
material to what instruction you take.
If they will both.
Only thing is you keep on pending the file the petition, let it be pending kind of.
No.
So after 1 week laga do.
Next week I needed, Your Lordship.
1 week after.
So
Yes.
may I pray one thing also, Your Lordship, kindly permit to, Your Lordship, kindly direct to the call for the 161 statement of the victim.
That will be worst for you. In 164, everything she might have told. Don't get into it. Yes. Yes.
May I pray, Your Lordship, can fix a date, Your Lordship?
Date will be fixed.
Yes. High low blast.
Yes.
Item 25, my lord. Day before yesterday, there one witness has been examined and the date has been fixed to 28th and 29th of this month. Can it be taken after the first week of
After 20th.
28th, 28th for him?
20th. Yes.
Obligement.
Yes.
30.
30. Yes. Bail. Offense. Non-APS. When the bail application was rejected? Six 10/2023. The petitioner is agreed by the order dated 6/10/2023, whereby his bail plea has been rejected. The petitioner in the on the last date of hearing, the petitioner none appeared for the petitioner. Even today in the second call, non-APS for today. Therefore, this petition, I am not inclined to keep this matter pending. Accordingly, the same is disposed of with a liberty to the petitioner to revive his bail plea before the trial court, before the trial. With this observation, the petition is disposed. Yes, next.
On behalf of one kindly next week.
Huh?
Next week.
Just see what is this matter first of. Adjournment is not by way of right, sir.
Out of Jaipur court को trial में देखने पे.
Huh?
Jaipur court को देखने.
See, you have been taking adjournment after adjournment. This matter is, I'll tell you, I'll give you the dates. These are bail matters. You will
No,
take
fine,
the
fine.
adjournment, and the impression is going outside that the High Court is not deciding. Our bail matters are pending for years. High Court is not able to decide. This is the impression you are giving. I'll tell you the dates. 1/2/2024, you short time. Next 8/2/2024, again time. Then again 7/3/2024, again
Yeah,
time.
last time.
And 1 minute. 24/2024, again time. And thereafter 19/7/24, again time. And you think that the High Court is only waiting for your arrival. And impression goes that we are not able to decide the application, bail application for 1 year, 2 years.
Last September.
No, no. You argue, otherwise I'll give you liberty. You revive your application. There is no res judicata or anything of that sort. Right now, the petitioner, this petition is pending since since 16/1/2024, and the matter in between was heard as many as 1, 2, 3, 4, 5, 6. 6 hearing has already been taken place, and the matter is getting adjourned. The bail plea of the petitioner was rejected by the court below on when it was rejected on 10/8/2023. 10/8/2023. Since 1 year, about 1 year back, the bail application was rejected. Bail plea of the petitioner is rejected. It would be appropriate that the petitioner shall move to the trial court by renewing his bail plea. With this observation, the petition is disposed of. 1 year back, in August 2023, your bail plea was rejected. Much has changed in between. You can move a fresh application. Yes. Yes, sir, please.
44.
It's a teenage law, my lord. 15 years girl, 19 years boy. Initially, FNR section 363, converted to 376.
See, the court has issued notice to the informant.
That statement is there. That is there in the court record. Also, can have a glance. That is there.
Complete.
No. A order was passed to record the statement.
Issue notice to the informant by registered AD and so and so. That is
That is has appeared. And pursuant to order of this honorable court also, his statement has also been recorded, and that has also been sent to the court itself. That is there in the record.
Yes.
And
okay.
Here the accused is in custody since 15/8/2023.
Okay.
And fact remains, my lord, that on 22/7/2003, after taking meal when the family they were asleep, my lord, they found at about 2 a.m. the daughter was not in the house. They sought her in different places. They could not trace her out. Fact remains, both were left. About 2 days, they stayed in different places, and there also they have consummated their. And my lord, after 2 days, the father of the petitioner came to know about their address, my lord. He went there. ତାକୁ ଯଦି ବୁଝେଇଲା ଯେ ତମମାନଙ୍କୁ ବୟସ ହେଲେ ମୁଁ ବାହାଘର କରିଦେବି. Thereafter he took them to their house. ଝିଅକୁ ନେଇକି ତା ଘରେ ଛାଡ଼ିଲା. And after that, his son is arrested. And now, my lord, in the meantime, charge sheet has also been submitted, and he is in custody. Fact remains, my lord.
You tell me, victim is examined or not?
Examined, my lord. The statement has also been said. That is there in the court record.
Because this court had directed on 22/4/2024 for examining the victim.
That is there.
So
examination has also been
let us
made.
see, where is that victim statement?
And 161 statement of the victim also I have annexed. That is an annexure 3.
What does she says then? Read the victim statement. No, victim. The court had directed that victim should be examined first. Victim was examined.
So directly court को पठाया था. That is there in the court record, madam. That is there in the court record. The line special court is sent it to the court. That is there in the court record. On the last occasion, it was shown in the cause list, my lord. अरे आसित ला bro.
No, it's there. Petitioner is victim.
Victim.
Informed his father, so I cannot say the exact date of incident, but about 1 year ago, it would be. I don't know.
What to be in court? Direct court particular court. Okay.
Have you read the statement?
I have not gone through, madam.
She has very categorically made allegations against. Also 164 reference here.
In the 161, my lord.
And she
15
suffered, she suffered cross-examination, lengthy cross-examination, but nothing is elucidated.
That means, my lord, that it is a case of law affair. No doubt there are the teenagers, my lord. But fact, after that, once he was rescued, my lord, that all these things have been come up. But 161 statement, which I was annexed with in my
But now,
petition.
how to get out of this prosecutory evidence? It is very, you just read it. The pursuant to the the pursuant to the order dated. I am giving you an opportunity. Just read it and pursuant to the order dated 22/4/2024. The statement of the victim has already been recorded by the trial court, which is placed on record. Counsel for the petitioner seeks time to study the statement and address the court on merits. At least 1 week of. Just see, it is there. Thereafter, do you have anything to say? Or you tell me. Yes. 1 week. 1 week.
We'll fix a date after that.
Meanwhile, you just see how many witnesses are still there.
No.
It's a case of conviction.
Witnesses.
It's a case of.
That will go.
Yes.
45. My lord, Mr. BP does let's kindly grant short pass over.
Pass over at this stage. What?
We're just coming from court note 5, my lord.
Bail matter? 1 week. 6 instruction. I'm putting it in 1 week. The idea is you seek instruction. 46 years.
46 may I please, your lordship. Lordship, I am pressing in the 46 in BLAPL number 982 and IA was filed on 768 of 2024, your lordship. On that the present petitioner's wife health condition was not good.
What is the offense?
Offense under 22B
Recovery?
C of NDPS Act, your lordship.
Recovery?
Recovery of quantity 1,991 kg, your lordship.
1,000 kilo. 1,000 kilo.
My lord. 1,091 kg. 1,991 kg.
You're carrying in a truck or what? Or railway, train?
Pickup van, your lordship. My lord, I am pressing the interim bail, your lordship.
The interim bail, you are planning to.
No, your lordship, I am the local.
You have a better plan in.
No, your lordship.
In store. What is the medical agency?
Lordship, medical agency. I'm annexed.
Wife is not well, huh?
My lord. Suffering for
Medical
DUIP.
paper? Medical officer. Government Medical College?
My lord. CORAM.
Admitted to
Last
higher.
Last.
She is suffering for what?
My lord, page 2 of.
Tell me you are suffering. I can't read it.
Dysfunctional uterine bleeding, your lordship.
Chronic?
Dysfunctional uterine bleeding, your lordship. Though uterus problems is there.
Cancer? You have cancer?
No, your lordship. Just better treatment. The petition is needed to be.
Some exclude genital cancer.
My lord.
Verify it.
I'll solve the two.
Interim verification. No? Verification. Interim. If she's suffering from cancer, then.
No sanction.
Yes.
My lord.
Huh? Oh. Yes.
My lord.
Yes. Bail granted when? Bail rejected when? No, write anything. That's the problem. Oh, June 24. None appears for the petitioner in the second call. On the last date of hearing also none appeared. Dismissed for non-prosecution.
48.
In the bail applications are dismissed and non-prosecution is neither here nor there. They can move fresh application. Yes, no prejudice basically.
Here I have filed application, interim application or the interlocutory application.
48.
48.
Yes.
For modification of order dated 12/7/2024.
12/7. What happened here?
In fact, my lord, that the appeal is pending before the lower court, my lord, before the appellate court. My bail application and restitution file has been rejected. Against that order, I preferred this CRLMA. And your lordship was on 15/7/2024, my lord. Your lordship was pleased to allow the bail and stay has also been stayed. The relation of fine has also been stayed. But a humble submission, lordship can have a glance. The order dated 12/7/2024. The condition number 2, so far as condition number 1 is concerned, petitioner shall not involve himself so and so that but so far as petitioner that
He shall cooperate with the investigation.
investigation. It is after conviction.
Already filed.
Right.
Oh,
And the next one is also, he shall not tamper with the evidence in any manner. But now the case is at the bail order now the case is at appellate stage.
Appellate stage.
Lordship.
Right.
And the next one is, my lord, that so far as the stay.
This is a copy paste business. Copy paste.
And so far as the stay relation of fine is concerned, that one line is that that is stayed till disposal of instead of CRLA, it has been mentioned as CRLMA.
Have you written everything in the application?
Yes, madam. Everything.
We'll correct it accordingly.
That
There are lot of correction.
That I have stated in para 4.
Whatever corrections are there, do it. And your condition number 1 and 2 enough.
CRLMA, CRLA.
2 and 3. That condition will also go. Yes.
CRLMA, CRLA.
By the way, who is written it? Let us see. Who is the author?
Till this stay relation of file till disposal of CRLA. So CRLMA is.
So done. Just check it up. Huh? To copy paste mar deejiye. Yes.
49.
May I please, your lordship?
Yes.
Lordship, on the last occasion, Lordship made an order where Lordship said the learned counsel for the opposite party number 2 submits that the undertaking he had given to the court to pay the disputed amount to the petitioner shall be complied with, but he would pay it on some installments. He further submits that once the said amount is paid.
Check amount. What is the check amount?
Check amount. Lordship, my client, he has himself come to ventilate some of his grievances for the
check amount. You tell me.
Check amount. Any amount you, Lordship said, it may be 2 lakh, it may be 2 point.
You have been convicted, huh?
No.
What is this matter?
Condition, yes. Subject to payment of some amount to show his bona fide first, then he would pay it by installments. Then time would be extended. Lordship said this. After that.
So bona fide doesn't mean that you produce.
No. In fact, Lordship, I would pray.
No, I don't want to look at it.
No,
you have to show. Don't bring all this theoretic.
Lordship.
You have taken admitted pay, finish it up. And I understand it.
I bow down.
You say that you have a financial difficulty. Everybody's life this happens. So therefore, I said that try and persuade, give in an installment and see, otherwise it will be cancelled.
I bow down to you, Lordship.
You made a statement in the court.
Yes.
That I am going to pay 5.5.
But in the meantime.
On that basis, your statement was recorded. Thereafter, bail is granted.
For one final time.
Then you say that I will not pay.
No, Lordship, for one final time, Lordship may kindly be that much, this benevolent Lordship to hear him out once.
No.
He just has this prayer.
He is being represented by a lawyer. Then you withdraw yourself. I'll hear it. What is this trick? While taking bail, you have all pleas. I will give this, I will give that. Once you get the bail, a concession is recorded, then you play all these dramas.
He also filed the undertaking before the trial court.
You have violated undertaking. Your own undertaking.
Therefore, he has come personally, Lordship, to buy some more time and to convince your Lordship.
The other day I told you that I will accommodate. He may be having some problem.
Yes.
Come with some money, show the color of money to him so that at least he will accommodate.
Lordship, once he sells his land,
He's totally ready. He's completely ready to repay the whole amount.
Do you suggest that I should purchase it?
No, no.
What are you trying to tell?
I'm praying, Lordship, that if
Last time you wasted about 15, 20.
if the other party is willing to purchase the land, Lordship, he is ready to totally sell the land and pay.
The police will arrange a buyer, a purchaser. The informant will arrange, or I will arrange. You tell me. You suggest so that three of us will try and get some customer for you.
I understand that, but there is some humanitarian concern. Therefore, I just approach. Yes.
And in place of that 5 lakhs for 50,000, and the property surety, let him give property surety. The same property which you are not able to sell it. Give it.
Actually,
not have both. You say that I'll sell it and pay. That same property you put it as a security in place of 5.5.
The rest of the amount.
The rest I don't know. I'm only interested in the compliance of the court order. Because you made the statement on that basis, bail is granted. Thereafter, you went to the trial court, gave an undertaking. You were released. You have to comply that order. And the other day I said that to show bona fide, come with some money. Some 1,50,000, 120,000, whatever. You say, come and show him. You persuade him. I'm giving one more week, next week. But don't bring these exhibits here.
2 weeks, Lordship,
I don't know. Ask him. Ask him and get a date. Next item.
50.
Lordship.
Otherwise I'll cancel the bail. I must tell you. This is
may I prefer 2 weeks, Lordship, because if you arrange sale
after the court hour, you come and see what date he can give. Yes.
50.
Yes. Yes, sir.
Yes, this is that software engineer I was talking about. He was going on a scooter, and when they
yes,
tried to apprehend him, I placed the charge sheet on record, my lords. He just swerved away, and he also fell down, my lords. And he had
one line is added.
One line and
yes, Mr. Raghunath, just see what can be done. You know the story, na? You know the story. See,
Corona time, this was happening.
Corona time, he was going in a scooter. He saw the police and took a U-turn and going, he fell down. When the police came, obviously out of this thing, he might have scolded.
One day, what happened in Corona time, I being the petitioner, filed PIL before this honorable court, I am the counsel also petitioner, my lord. In that case, my lord, this honorable court passed an order, division bench, that no vehicle should be kept in the police station. On the other day, all the throughout the country, throughout the state, all persons came out to the road and but the vehicle police remained silent and came to this court and filed affidavit. In my case.
I'll quash it. On this ground.
Well, obliged.
Because this, see, young man, his career is at stake. Unnecessary.
well, as he's working in Accenture, he's a software engineer. I've given that certificate also. He's working in.
It is there in the record?
39 yes.
40 of the memo.
39 and 40 of the memo.
I told you to give a small note. Why have you not given?
Your lordship said.
I'll file I'm not asking you, sir. I'm asking him. Because it is his job. He has to prepare a note.
Well,
a small written note, judgment reserve, so a small written note will give.
But on Monday, my lords, in course.
No.
Yes. Obliged.
And if you want to say something, also I'll record it because it shouldn't go in your head. On merit, I'll decide.
Police is the informant.
Police is informant.
Yes, yes.
Unnecessary.
Yes.
You also place on record some 1 page or 2 page written note so that you have also done your job.
Right.
Okay.
Obliged.
51.
Judgment result, both departments to file the written submission, not exceeding 5 pages. You also not exceeding 5 pages, you place on record so that I can take, I'll take it on record so that it shouldn't happen that you have not opposed.
I'll file contradicting the assumption.
Whatever.
You want?
May I please, Your Lords?
And you give that example also, the PIL which you have filed.
Here the petitioner is the husband and opposite by the wife also. The wife filed an application on 12 of the domestic
That
violence
itself is the offense.
for maintenance lordship.
Yes.
And also filed an interim application on 23 for the said act for interim maintenance lordship.
What was the order?
The order is 5,000 per month lordship.
Yes.
I am a labor class people. And the petition was presented by the opposite party, not alone a lordship.
Why, when at the time of marriage, you were all right? Not labor.
Labor.
Now, after marriage, you become.
No, I'm labor lordship. From the beginning, I'm labor lordship. Today, I'm also doing labor work. But she filed a lordship the petition for herself and for a minor child. The minor child, while she left my company lordship, she left the minor child in my custody. Still now she is mine with your lordship.
Child is with you.
With me, your lordship. And now compensation average for month has been directed to pay 5,000.
Show me something on record that the child is with you.
Yes, this is the your lordship a glance. Page 24.
24.
Page 24 of the impugned judgment.
Yes, 24. This is the what? This is the order.
This is the order, lordship. My submission, the agreed person left the company of the husband, voluntarily leaving her only female child, who is leading happy prosperous life in the house of the respondent.
That you have said, nah?
That my submission. That is the interim application, lordship, for which that has not been unless until a evidence has been collected that cannot be proved. The interim application stage only it has been environment of the respective party.
Whether she has filed a reply to your application.
No, your lordship. No, your lordship. She filed a lordship application, I filed objection, then order has been passed. And another thing, your lordship glance, after that, your lordship, there is a compromise.
Notice was not issued.
Not issued, your
So
lordship.
issue notice. Let us see. Take notice and serve immediately. We'll see. If only on the ground that the girl child is with you, 5,000 is awarded, 2,500, 2,500, isn't it?
No, it has not been segregated. It's stated to be 5,000.
For both.
Yes, yes.
If the girl child is with you, she is not entitled for maintenance insofar as that girl child is concerned.
Yes, sir.
For herself, she may be entitled.
Thereafter, another thing, also glance page 27, annex 6. There was a village punch. In the village punch, that fate has been admitted and she has been taken a lot of compensation.
Let her come, we'll see. Let her come.
Shall I pray, Lord, so far making payment
After
of
one
the
week. No stay. Maintenance is not stay.
subject to payment of rupees some amount, the order may can be stayed, Lord.
Why unnecessary? I'm putting it like 1 week after. I'll decide it. I'll decide it. 1 week after the moment I give stay order, the requisite will never come.
No,
for years together.
specific date, Lord.
I know that.
I'll undertake
Thereafter
to
you will not be found. You will can come
I'm
on.
there, Lord.
Adjournment.
Yesterday, Lord, I was there. Today, Lord, posted. I'm here, Lord.
No, 2 weeks. 1 week after. 1 week after.
Lord, glad 3 4 criminal benches are functional. We are around roaming one court another.
That's
so
good.
Sometime I'm able to attend the court and the matter has been called.
That is good for you. 1 week after this, you file the requisite.
Requires by tomorrow
Today itself. You file.
Yes, sir. In course of the
serve it so that immediately I'll reduce to that extent. If
through speed post.
Speed post.
By Monday, Lord. Should take Punani possible by Monday.
By Monday. Okay. By Monday. 52. Good week पर छड़ी दे दिया. Yes. 52. Yes.
May I please, on behalf of Mr. P.R. Singh, may I be permitted to submit? On behalf of Mr. P.R. Singh. My lord, this 138 Cognizance order has been challenged in this matter, your lordship.
Accused.
Dictionary of the check is due to the account is closed. Account is closed since 2019. The complainant and the petitioner herein were running a partnership business. Thereafter, some disturbances started. Then he took away the check was he came to know the petitioner came to know that the check was.
All these things are your defenses.
My lord.
Cognizance is taken.
Cognizance has been taken.
You can have.
I have also lodged a case against him.
All these things are defense. What is wrong in cognizance? You see the complaint.
Yes, your lordship.
If you read the complaint, there is no court can interfere. Rightly taken cognizance. What is the check amount?
5 lakhs, your lordship. It's a check of 2019. The account is closed. He's depositing in 2022 on a daily basis. And there is business relationship between them and partnership business was there. And he took out the check, and thereafter this, he issued the check demand notice. Then I came to know that it has been taken from the custody of from the office itself. That so therefore I lodged a complaint, 1cc case.
Subject to you paying 20%, I will issue notice. Because 143 says.
140 is not mandatory. You also know that.
But
that
I will examine.
And now only thing
Idea is if you give 20%, I will issue notice. Once he comes, I'll try to get it settled. That's the idea.
No, it's a
not for
the account is closed in 2019.
All these things are different, and then I'll dispose it up. Huh? Accordingly. Right now, the petitioner is agreed by the order dated 10/11/2022, passed by the court of JMFC Burville in 1cc case number 49 of 2022, whereby the court below had taken cognizance of offence under section 138 NIS against the petitioner, Perusal of the complaint reveals that the petitioner has issued a check of rupees 5 lakhs on presentation of the same. Presentation is received, the check was returned the journal. Therefore, the petitioner was therefore the petitioner is prosecuted by the opposite party. The specific allegations are made in the complaint, and subsequent evidence is also recorded by the court below. Therefore, I don't find no reason to interfere in this matter. Accordingly, the petition is disposed of with the liberty to the petitioner to raise all the points before the trial court at the appropriate stage. And
I have also filed.
It also expected that the trial court should make endeavor to see that the parties explore the possibility of settlement at the possibility of settlement.
I have filed a case also, my lord.
You can settle also. I have indicated. Yes. Next. Yes.
The petition is my informant, my lord. They lost the FIR on since 2019, my lord. Trial has not been commenced, and the offence under section, my lord, 376 and 370 of Indian Penal Code, lordship. My lord, the present petitioner, my lord, filed a petition under section 302 of the CRPC, my lord, to conduct the case in personal and to expedite the trial. Trial has not been commenced till date, my lord. The petition of trial lordship to direct the London trial court, my lord.
You move an application,
my lord,
under 3022
CRPC, my lord, to conduct the case personal, though there is delay in trial, my lord.
What happened to this application?
My lord, still pending, my lord. This petition has not been
this
disposed.
application is to be disposed of.
My
petitioner is agreed. Petitioner moved an application. You are the informant.
My lord.
Petitioner is the informant in the FIR. He moved an application under section 302(2) of CRPC. CRPC inter alia praying. Inter alia praying that she may be allowed to appear and prosecute the case in the capacity of informant. This application is pending. Hence, the petitioner is agreed. Agreed and seek the indulgence of this court. Regarding here to the fact that the application has been moved by the petitioner on application. When you move the application, date is not there.
4th additional session, Judge Lordship.
No, when have you moved? There is no date, there is nothing.
The annexure,
I know, where is the date, sir?
My lord, the Hearing date, Lordship, and the till
I'm
date.
asking when have you moved this application?
My lord, the petition filed, my lord, that hearing date has not been
I'm
till.
asking when did you move this application before trial?
My lord, 29/3/2023.
Where is that? Where will I get?
My lord, I am page 19, Lordship, have a glance. Page 19, my
Where is
lord,
that?
23/9/2020. My lord, 29/3/2022.
On 29/3/2022.
22.
And the same is pending till date. Till date, the trial court is directed to dispose of the application on its own merit with this observation petition.
Another criminal trial may be expedited, Lordship.
No, I don't know.
My lord, that is another application, my lord. If the Lordship. Another second, my lord.
I don't know how many.
My lord, 8/4, Lordship, if I permit to.
Not
My lord, I permit to this application, permit to withdraw, my lord, another sub item, if Lordship may expedite the time.
But
That
this is not assigned to me.
My lord, in this case, Lordship may pass inherent power, exercise the inherent power, Lordship.
The petitioner seeks to withdraw this petition to avail remedy under law.
My lord, this
much I can do. I can't pass the order.
My lord, sub item, my lord.
Sub item only.
My lord, let me live over. I'm moving the appropriate form, Lordship, another bench, Lordship. If another CRL.
You want to withdraw or you want let it be listed?
My lord, let me list me the.
I don't
My lord,
since
delisted, my lord, I
since
pray.
it's,
Sub item, Lordship.
this
So far,
is
sub
not,
items.
in the assignment of this court. Let it be listed before the assignment subject to approval. Automatic. So automatic जाने तो
Fine.
छोड़ दो.
Obliged, Lordship.
निकाल delist करो first now.
54. 4197/2023. I am 23. I am permitted to withdraw, madam.
Withdraw.
Another the 50885, madam. That is I pray 1 week after, madam.
नहीं. Which one? 54.
54.
Which one?
Parallel sub item.
4197 withdraw and 5085.
1 week after.
Oh, adjourn करो. ठीक है. 55.
Lordship, petitioner want to withdraw this application and give liberty file a better application.
Petitioner seeks to withdraw this petition to file a better one.
Lordship, certified copy maybe.
Liberty dispose with the liberty to file avail remedy under law. The certified copy filed in this petition shall be returned to the petitioner, substituted by a photocopy. Yes.
56. Copy not served. Copy not served. They have not given copies.
What is this matter?
Not given copies.
It was filed November 23. This is filed. Seeking what?
Pending a charge. Pending a charge in POCSO case. 372 in.
I'll dismiss it for non-prosecution. Non-appeals for the petitioner or despite second call. The matter
Not second call.
the matter is pending before this court since 29/11/2023. It appears the petitioner is not interested to prosecute the same. Dismiss. Yes.
57.
May Lordship.
Yes, sir.
Offense under section 498, 323, 325, 506 of Indian Penal Code. The petitioner is the husband and the petitioner.
What do you want? Washing.
Washing, my lord. There is every possibility to reunion the matter, my lord.
Bail rejected.
No bail rejected. 41 was complied. I pray for the matter may be remitted to the mediation center.
What is the offense you said?
498. 498.
Matrimonial dispute.
Husband and wife. 11 years ago, marriage was solemnized. There is no issue. That's why the discharge.
See, mediation, these criminal matters, I can't, because 323 is there. Had it been 498, I can understand. 506 is there. You want to settle it and tell me, I'll pass it.
is to issue notice to the opposite party to.
I'll issue notice.
Yes.
Don't ask anything else, huh?
Yes.
Issue notice to
Opposite party to.
petitioner seeks passing up for the FIR number so and so. This matter is arising out of a matrimonial dispute. Therefore, issue notice to opposite party number 2. Written evidence also. Yes. Next.
28.
Requisite by Monday.
By Monday. Bring her if settlement is possible. I'll cause here.
Please, Your Lordship. Here is petitioner is challenging the order of a cognizance. Taken by the 9/3/2018.
Cognizance.
It's a total false case.
Whatever, but what is the stage of the trial?
Says my lord, 7 witnesses has been examined.
At this stage, how do you expect cognizance of trial?
My lord,
the petitioner is agreed by the order dated 19/3/2018, whereby the trial court passed by learned JMFC, come ASJ, Jagat Singhpur in so and so, whereby the trial court has taken cognizance of the offence. Within this span of about 3 years, about 3 years, trial has already proceeded substantially. 7 witnesses. Seven prosecution witnesses had already been examined. So therefore, at this stage, I am not inclined to interfere with the impugn order. However, liberty is granted to the petitioner to raise all the points before the trial court at the
only one point, my lord. The independent is a false case. Police was instructed. Police is the informant, and the witnesses, independent witnesses introduced in this case. None of the witnesses out of 4, 3%, no such person are residing on that place. Someone.
You tell me 7 witnesses have been examined.
One is doctor.
If anything might have come against you, can I throw it?
No, ma'am.
I can't look at it also because it is a cognizance. Beyond anything which has happened beyond cognizance, I can't look at it. Something has happened. The court has to see that. Yes.
59.
Disposal.
Was the final form dated 30/5/2021 arising out of circumstantial?
My lord, the council seeks 3 weeks time for the removal of the defect.
What is this matter? First tell me.
My lord, it's a matter to quash the final form, my lord. Then dated 35/2021.
Final form has already been filed. Who
Yes,
are
my
you?
lord.
Who are you?
I am the petitioner. In the as per the affair, I am the accused.
Accused.
Yes, ma'am.
If final form is filed, what is the problem?
My lord, my lord, actually, I want for the time for the removal of the defect.
Forget about defect. What is your grievance?
My lord, the actual matter is the affair constituted in this matter does not reveal about the offences that was given in the name.
Huh?
The actual, my lord, in the affair, it does not mention about 341 and all that. Along with that, my lord, the petitioner has not committed such offence. My lord, the petitioner came to know about this matter when he had gone to file the passport.
What are the offences? 341, 323, 294, 34. There are direct allegations.
Both the cases manners 59 and 60 manner. 2 active persons, 2 separate.
There are direct allegations against you. '59 and 60.
Both salary out one piece.
The SR pointed out that these petitions are pending since date लिख दो एक कुछ 11/2020 हाँ तो एक कुछ 11/2020 the SR has pointed out certain defects. The defects have not yet been cured by the petitioner. 2 working day is granted to the petitioner to cure the defect. If the defect is not cured by Tuesday, by then the matter shall be dismissed without reference to the court. If the defect is cured, leacher on Friday. Therefore, I am giving.
For that reason, to that time given.
I'll just tell him. I'll just tell him. I know. See, I have given 2 days time to cure the defects. If you don't cure the defect, the matters will be dismissed.
Okay,
If you
my lord.
cure the defect, then it will be listed on Friday.
Okay, my lord.
Both the matter. Yes. 61. He's young counsel. That's the reason they give him. No, otherwise they would have dismissed. Yes.
2 working day that.
Working day.
2 working.
Tuesday. Monday, Tuesday. Yes.
60 61. 61.
60 na? 60 same. खाली date लिख दो. Date. Who date file लिखा? 60 हाँ. This is 61 na?
60.
Item 61, may I praise your lordship? My lord, the allegation is under 420 and 34 of IPC. My lord, the date of occurrence is 7th of April 2023. But my lord, after 4 months, the informant has lodged this affair on dated 7/8/2023. And my lord, in the affair, there is no proper justification regarding the delay in registering the affair. When the my lord, the allegation is as per the informant has given 5 lakhs rupees to the accused person, and the accused person flee away from the spot with those 5 lakhs rupees with him. And my lord, the incident happened in Pahada, but the same date, my lord, the informant has not registered the affair. And after 4 months, he has registered the affair with an ulterior motive. My lord, the petitioner has no involvement in this.
Then you have only one ground, that delay in registration. But that will be, see, prosecution will explain the delay.
My lord,
In
also,
the right stage.
also under 161 statement, my lord, the informant has stated that on the same date, he has withdrawn 5 lakhs rupees from the bank. My lord,
You have.
my lord, the informant withdraw the 5 lakhs rupees from the bank, and he has handed over the rupees to the accused person, my lord. My lord, 7th of April 2023 was Good Friday, and it was a holiday.
We might have got it from ATM also.
My lord, he has stated that he withdrawn the, my lord, from the ATM, such big amount cannot be.
We don't know limit, maybe.
No, that will be decided at the
All
court
these
trial,
things,
whether it was withdrawn by
trial
ATM
only.
or.
My lord, defect.
You are on bail.
Yes, my lord.
What best could be given in this petition, you tell me, except quashing.
My lord.
Think over and tell me. I can accommodate you. I'll put it on Monday, you tell me. But you have to come. Otherwise, anybody else come, I'll dismiss it.
Oh, bless
You
me.
and you come and tell me what best could be taken from this proceeding, from this court. Take it.
Oh, bless me, lord.
Relief. Let her explore possibility. Think over. Cure the defects also by now. By then. I'll put it on Tuesday. Cure the defect on Monday. And Tuesday you come and address.
Oh, bless me, lord.
Tuesday rako. And letter counsel for the petitioner submits that she will cure the defect by Monday. Lease the matter on Tuesday. Okay.
Oh, bless my lord. Deeply
Yes.
please.
There is a quashing of affair, my lord.
Yes.
And the offense is under section.
Is it 341, 323, 307, 452.
Half of the IPC is there again.
Allegation is assaulted by means of iron.
My lord.
See, such a long
In the mid period, compromise understanding is going on. That has been failed now, and the case counter case and the present petitioner also injured in another case also. I have subsequently filed that document, and Last time your lordship granted 1 month time for as the father of the petitioner. The
Why should I quash it? So many facts are there. The cross case is there. 307. All the offences.
Civil dispute is there, my lord. I have also
Those things
avoided.
should be tested. How can I quash the proceeding at this stage? I don't understand.
Para 6 also I have annexed.
You might have said that all these things are to be settled in the trial.
My lord,
Unless there is a startling fact where it says that nothing is made out. Those kind of things. See,
the father is now in a serious condition. I also.
that's right, but what
You will also have a glance. Record some operation.
is this a ground?
No, my lord. For humanitarian ground, my.
Humanitarian ground, how can I quash it? 307 and all. And see the offences.
3 persons sustained injuries, my lord.
3% sustained injuries. 341, 323, 294, 225, 307, 452, 427, 506.
Entire allegation is.
What not?
Focused on Sukanta Sahu. So other that another the.
What is this case?
CD ଦେଇଛନ୍ତି CD
ଗୋଟେ ଚାର୍ଜସିଟ୍ ଫାଇଲ୍ ହେଇନି
କେସ୍ ଡାଏରୀ ଆସିଛି my lord case diary
no earlier bail rejected by honorable justice.
That's the problem. Bail rejected, therefore he is filed.
All the avenue have been closed, my lord. I used to go.
What to do? You have closed it out.
They are facing a lot of difficulties due to the
what is
their
the health condition?
father, my lord.
Health condition too. Health condition too.
I also have an.
You tell me health condition. What is the problem?
And the
gentleman, Sukanta Sahu.
Father of the Sukanta Sahu.
You talk about Sukant Sahu.
Father of the
Suresh Sahu, Sukant Sahu.
Yes, petitioner's father, my lord. Profulla Sahu.
Can't help you also. I thought that if you yourself is having some health problem, even if the bail is rejected, I'll give something to you.
They are facing difficulties to treatment for their father.
Difficulty in your domestic this thing is not a ground for quashing an FIR.
And the injured.
And your father is not well. I don't have money to eat, so therefore quash it. What is this?
That now on the also that injured person is hell and happy, my lord. I have also.
He is very lucky. He's very lucky that after you assaulted also
sustain grievous injury on the head, my lord.
It's a family dispute, and in a sustained grievous injury, so far as petitioner 1 is concerned.
I don't know why are you not getting practical. You know that I can't quash it. Still you will go on and on. What best you can take it from this court, you think over that. Try to be practical. I'll dismiss it, and you the whatever avenue is there, that is also closed. Why don't you have a practical problem? You simply say, I know that you can't quash because of these circumstances. Please give me this. Then I'll consider. I'll ask him how to find out the way.
Surrender.
Come to that. Come to that point. You know that I can't quash.
Every avenue has been closed.
And your bail application is rejected. Everything is, you close all the doors and unnecessary waiting.
Antecedent is there.
Antecedent is
there.
Huh?
No antecedent is there. That counter case, that is not the counter case. This case is one PS and which case here
nobody can help you.
That the injured also is also made
injured also very bad man. So therefore
injured also have been against him also FIR has been lodged for. I have annexed.
Then he is antisocial. So therefore you go and beat him.
Like that, I have also filed the on 18/4/2024. That injured how.
Let count for the petition seeks to withdraw this petition to surrender before the appear before the court below and seek appropriate remedy under law. And he submits that whatever you want to tell me, so that will help you in getting bail.
Within 1 month, till that period, no action.
Okay. On instruction he submits that his client would appear before the court on or before 31st of August,
By 10th
2024,
September.
2024,
By 10th.
and move appropriate application for grant of bail. I'm alive of the fact that the coordinate bench is rejected your application. Who is rejected? The bail, the bail plea of the petitioners have already been rejected by this
Person have been
court,
granted.
by this court, but the fact remains that the a couple of co-accused persons have already been granted bail. Granted bail. Therefore, the petitioner is given liberty to move appropriate application for the court below on or before 31st August onward 31st. Till then, no court action shall be taken.
Till 10th September. Because
next time.
And not set in the.
I should not have passed this order because I am bypassing an order passed by a coordinate bench.
Obliged. Greatly obliged.
This is in fact not done.
I know.
Therefore, I have written that I am alive of this fact that the coordinate bench is rejected. Still, I am giving because of these 2 or 3 issues.
Parity may be granted, maintained.
Don't cross a particular limit, you know. I can't give, you know that. Yes, next.
64.
64, my lord, next week.
What is this matter?
Matter, my lord, I have not gone through the matter.
Okay.
Next week, my lord.
Okay, fair enough. Next week, he is not prepared. Yes.
66.
Where will not extension of my lord, extension of surrender.
Extension
of surrender.
That is order dated 25/24.
25/24.
My lord.
How much time you want?
15 days.
15 days. 20th August, huh?
My lord.
Public appear before the court. Time is extended. By the order dated 28/5/2024. This court directed the petitioner to appear surrender before the court below by 30th June 2024 and seek appropriate remedy available to him under law. For the reasons stated in the application, the petitioner seeks extension of time. The same is allowed and so.
Obliged.
Next.
68.
Would you mind if I say 2 lines before you start?
Yes.
So that can be disposed of, if you like it. Your lordship can, this is the revision, my lords. They directed against an order by which discharge application rejected, my lords. There are 2 points my lord friend raised that was turned down by the Lord High Court. That's why my lord friend is before lordship. Your lordship turn to page 101, lords. Exactly at 101.
101.
Your lordship 106 will be do.
Annexure.
Well, annexure page 106, my lord, the part of that impugn orders. 106. The impugn order starts from 104, but at page 106, the impugn order starts, my lords. 106.
Yes.
My lord friend is correctly, my lord. He is that I'm placing that ground second para, my lords. The grounds for discharge of the accused mainly on 2 grounds. Firstly, the accused was not a public servant as per section 2C9 of the Prevention Corruption Act. In support of such contention, Lord Counsel for the accused relied upon the opinion of the Honorable Justice A. Suryanarayan Naidu, received by the bank on 5/9/2011. Second ground, the sanction order was not a valid one. Lords, you can see that it was not a valid one as provided on section 19 of the Prevention Corruption. My lord, these are the 2 issues, my lord, which are pure question of law, public importance, my lord. With regard to second point, my lords, that law has been set into rest, my lords. Lords, which I were aired 2007 Supreme Court 1274 in Prakash Singh Badal judgment, my lord. On Supreme Court said, if there is a no case, if with regard to sanction, obtaining sanction, if it is falls within category of no sanction, then it can be raised at threshold. If it's a case of invalid sanction, or then it can be raised at the trial court. So this point is no more raised at the Lord. This can my learned friend may be given the liberty to raise it, lords. So with regard to first point, my lord, the accused in this case is working in executives, my lords, in a private banks, my lord. Now my learned friend's case is that
Not private bank.
It's a cooperative bank. It's a cooperating bank that his case is that is not receive any grant and on all these things, my lords.
RBI guideline, you were saying.
No, my lord, that is his case, my lord. My humble submission, my lord, he relies a judgment, my lords. I rely a particular judgment, my lords. I just place 2 lines, my lord. This point, whether Jyotiu,
Ramesh Gill.
a few lines alone place the entire thing, my lords.
Yes.
My lord, this is a very comprehensive judgment. One of the few judgment were on Supreme Courts, my lord. Citation they reach, Parthak Desh, 2016.
CBI versus Ramesh Gill.
Lordship may turn to the first paragraph.
CBI versus Ramesh Gill.
Yes.
Yes. Yes.
Your Lordship can know the first paragraph, last line. On the ground that they are not public servant. Who last line is the courts will have held that the cognizance cannot be taken against the accused, namely Ramesh Gill, chairman, managing director, Siddharth, executive director, Global Trust Bank, on the ground that they are not public servant. This was the issue. Lordship turn to paragraph 16, Lords. Para 16, Lords. Lordship got it, Lord? Para 16, Your Lordship quoted section 2C of the Prevention Corruption. What is the public servants? Let's just keep that. Lordship turn to next page. Para 17, Lords. Para 17, this Honorable Supreme Court formulated the point. I'm placing para 17 or 2 lines more. The above definition shows that under subclause 8, contained in section 2C of the PC Act 1988, a person who holds an office by virtue of which he is authorized or required to perform any public duty is a public servant. Now, for the purpose of the present case, this court is required to examine as to whether the chairman / managing director or executive director of a private bank. This is the catch more. Operating under the license issued by RBI under the Banking Regulation Act 1948 holds an office of and performs public duty as to attract the definition of public servant quoted here. Lordship, just 2 lines. I'm unable to. Lordship, turn to page para 19. Lordship,
What you're trying to say is they are answering public duty. In lieu of the RBI guidelines.
No, because I have to distinguish that the earlier judgment will suffer from subsilento. Lordship, turn to paragraph 19, Lords. The next page, paragraph 19.
Yes.
Paragraph 19 says.
What most relevant? I have already underlined that.
Paragraph 19, yes. What is most relevant for the purpose of the case is section 47A of the Banking Act, which reads as follows: 46A, chairman, director, public servants, the purpose of the chapter of the Indian Penal Code. Every chairman who is appointed. I
read it.
Yeah, Lordship can turn to very important. Another judgments relied on paragraph 22, Lords. Lordship turn to middle portion. In our considered opinion, this is just even any grant of any ad at the time of establishment of the society or any construction or any structural concept or any aspect would be an ad. We are inclined to think so as to term ad has not been defined. Lordship can import a line say a sprinkle of ad to the society. A sprinkle of ad to society will also bring an employee within the definition of public servants. The concept is entirely has to be observed in the backdrop of corruption. Yes. Your Lordship may leave this one. Your Lordship kindly turn to para 30, Lords. 30, Lords. 30. Therefore, having, Your Lordship got it, Lord? Yes. Having considered the submission, having considered the submission made before us, and after going through the papers and records, the further keeping in mind
46A banking regulation.
Yes, you'll also want to skip the last portion, paragraph 45, the last page.
45, yes.
45. Turning to the case in hand, there can be no dispute that before the enactment of the PC Act, Section 46A of the BR Act had the effect of treating the employee and office bearer, important law. Here the petition is office bearers, concern of a banking company as a public servant for the purpose of chapter so and so. The enactment of PCI with the clear intent to widen the definition of public servants cannot be allowed to have the opposite effect by expressing judicial helplessness to rectify. Now, Lordship will turn to the petitioners.
I understood your point.
My Lord, I'm placing his points, my Lord. Lordship can turn to.
My point, he has to get over this now.
No, not only that. He another judgment of Supreme Court lends his supports. Lordship turn to the page. He has quoted that one, Lord. I will distinguish that. Page 7 of the petition, Lords.
Yes.
Page 7, Mods. I'm placing the second line. The statutory audit reports of the year 2008-9 and opinion of Justice A.S. Naidu makes it clear that Urban Cooperative Bank has not received any financial aid from the state government and central governments since inception. The Honorable
That
Apex
is a judgment of 2002. It's a recent judgment of 2016.
One. And secondly, my lord, this judgment of the Honorable Supreme Court will lend support to my learned friend's contention, my lords. Also, a good judgment in the facts of that case, but it suffers from the principle of subsilentum, my lord. Had Section 46 of that RBI Act put in place, the result could have been different, my lord. That's why, my lord, the co-equal bench, latter bench, my lord, followed that particular. People to ignore this one.
See, in that judgment, 46A is not.
Never, my lord. The statute provision which could have been placed, that judgment suffered from subsilentum.
Yes.
I will answer. My lord, first of all, this judgment.
You answer only one thing. My lord, are you regulated by RBI guidelines or not?
Only regulation.
That's all.
No control. No control. Only regulation.
That's all.
I'm answering. I'm answering.
Private banks are not, in fact, controlled. They are regulated by the RBI is a very regulatory body. Basically.
Only
RBI is a regulatory body.
My lord,
And the regulatory body is regulating.
Not only the licensee, they are provided the license to run.
I am trying to distinguish the
Yes.
case. Kindly. This case,
yes.
Here the issue was, the question before the Honorable Supreme Court was whether the chairman, director, officer of the Global Trust Bank Limited, a private bank, before its amalgamation with the Oriental Bank of Commerce, can be said to be a public servant.
Now it deals with 46A.
46A.
You tell me, how will you get out of the 46?
Before amendment of PC Act, the old PC Act 1947, public servant defined, public servant means public servant as defined under section 21 of the IPC. 21 of IPC
The FIR is in the old.
21 of IPC re sethre total 12 12 category of person rahile koane public servant. PC Act जेतला amendment हला 1988 रे सेटा ए public servant को से माने categorize करथन PC Act 1988 PC Act को categorize कले 12 type of person will come under the purview. सेतरे specifically IX 2C IX only meant for the or cooperative society. I am reading this provision. Any person who is the president, secretary, or other office bearer of a registered cooperative society engaged in culture, industry, trade, banking, receiving or having received any financial aid from the central government or state government or from any cooperative corporation established by or under central, provincial or state act, or any authority or body owned and or controlled or aided by the government or government company as defined in section 617 of Companies Act. এটা কাহিকে আনিলে কনস্টিটিউশন Constitution chapter IXB re article 243 ZI incorporation of cooperative society subject to provision of the part the legislature of a state may by law make provision with respect to incorporation regulation winding up cooperative society based on principle of voluntary formation democratic member control. Democratic member control. Member economic participation and autonomous function. Cooperative society, it is only controlled by its member. Democratic member control. The cooperative society function को देखी PC Act रे पकिया पे हेले specifically ओटे chapter ओटे legislature ଗୋଟେ provision add କଲେ IX को
Yes.
दे जो society state government or central government रू or any company ରୁ କିଛି aid ପାଉଥିବ ସେଇ society ର member ମାନେ public servant ର definition ଭିତରେ ଆସିବେ specifically ये article 243 ZI को देखी एटा को करा ହେଇଛି intention.
I'll tell you, the idea for these inclusion of this definition in public servant is because of there are two type of cooperative society. There are two cooperative society interbanking amongst the members takes place. The committee, five of us will have a committee. I pay, everybody will contribute. And that contribution, the lottery wise, one member will take with some additional this thing. That is a kind of banking. Likewise, a group housing society, where everybody will contribute to construct a house of society and they stay. These are the kind of society where there is nothing to do with the RBI and all. And those of societies are taken out. Those are the society culled out from the definition of public service. But the society where the banking operation is going on, not amongst the members, beyond the members also, then the regulation comes into play. That is 46A. 46. Once 46A comes to play, then it will be a public.
46A
when public is involved, public duty. If only members are involved, members.
46A को Banking Regulation Act 1946 मुझे place करছে.
That is paragraph 9.
Yes.
ମୁଁ act को धरছি. 46A.
Para 19 of the judgment.
Chairman, director, etc. to be public servant for the purpose of chapter IX of Indian Penal Code. Every chairman who is appointed on a full-time basis. Here in cooperative society bank, no chairman for full-time basis. The chairman is a nominated person, nominated by the member of the society, full-time basis. Managing director, auditor, liquidator.
I read it, everything. Yes.
Manager, any other employee of the banking company. My lord, this is not a banking company. What is banking company? It is defined under section 5C of the Banking Regulation Act. Banking company, 5C. Means any company which transact the business banking in India. A company must be registered.
Do you have any direct judgment in that?
गोटे केस आसीथिला सुप्रीम कोर्ट को सेटा रिमांड कर देले ओनली ए इशू करे ओनली आई एग्जामिन
What is the High Court judgment?
High Court judgment गोटे अछि
which holds the field.
They not direct on the issue, but cooperative, the employee of the cooperative bank are not the public servant.
So,
my lord, सेटा United Puri Nimapata Central Cooperative Bank Limited versus Praful Kumar Mishra.
Give me that. Give me that. You don't have a copy. You don't have a copy.
Here the petitioner is the chief executives.
Yes, if the society किंतु कोऑपरेटिव एक्ट रे चीफ एग्जीक्यूटिव की पब्लिक सर्वेंट भाବରେ कुहा जाईची मु सेटाई मतलब कोर्ट नोटिस को
you said that Supreme Court has remanded back the matter.
The trial court
to High Court. Which High Court?
Bombay High Court.
Bombay High Court.
नहीं सेटा बॉम्बे हाई कोर्ट रो से ट्रायल कोर्ट को रिमांड कर देले एटा को एग्जामिन करा बोली तापर आसी ना.
Where is that order?
That is Prabhakar Rao.
I will also remand.
This sir.
I will also remand. I will also remand. What to do? You have a conflicting judgment.
No,
conflicting judgment.
No, in fact, my lords, if lordship permits,
have you placed on anything on record? In what way they are being regulated by the RBI?
Yes, my lord. The catch is, my lord, the crush is, my lord, who is held chairman / managing director.
I'm not on that. Don't read the provision.
No,
evidence I am talking about. Evidence I am talking about. Have you placed on record anything to show that they are being regulated in this fashion?
Yes,
Any letter,
at
anything?
the outset, my lord, my submission, my lord, in fact, I requested him to place me, my lord. So they can be disposed of. This point is, your lordship record my submission, this may let him have the liberty to raise it, my lord, before the trial courts.
No, that's the second point. In any case
Both the points, both the points.
First, FIR is registered.
But what he says is the cognizance could not have been taken.
What?
That's what he says.
Because the answer to this query is, my lord, since the particular bank in which the petitioner is working, my lord, whatsoever the position, my lord, is operating under the license issued by the RBI under the Banking Regulation Act 948, holds an office and performs public duty so as to attract the definition of public servant for the purpose of PC Act. What more?
You are reading judgment.
No, the first page.
My lord,
Judgment.
if there is,
Now, what is the material to show that
if
they are
there is
being
any
regulated?
irregularities,
Yes,
if
my lord,
loan-
the lordship record my submission, let him have that option, my lord, to raise it before the trial courts notes.
the RBI, এই লোনটাকু
But he cannot say this, he doesn't have.
লোনটাকু RBI scrutinize করছি, that is in the record in my application. RBI has not raised any objection, but vigilance lodged the affair. Allegation is that the fabricated document, mortgage deed was executed without ROR, and valuation of land, building, machinery was evaluated by the.
That's
not
Where is the sanction order?
Sanction
Sanction is required.
Sanction is required. Sanction is a the petitioner is the.
He says it's invalid sanction.
That's what I'm saying.
President has accorded sanction.
Where is that? What is the language?
My lord, I'm page 121.
What is the extent of fraud? 1 crore.
No, no, it's
Yes, yes, one.
Recovery
3 crores 14 lakhs.
My lord,
Page 101, my lords.
My lord, loan was
3 crores 14 lakhs amounts, my lord. Page 101, my lords.
My lord, loan was sanctioned. Loan could not be recovered. Thereafter, bank auctioned for the property, recovered the
My
amount.
lord, at the end of the day, my lord, this is not a groundless case, my lord. In fact, there are material to proceed, my lord.
Which document you are showing?
My lord,
101, my lords.
121. The president first accorded the sanction. Thereafter, it was ratified in the board meeting. I am placing
at the end is invalid. I agree, my lord. At the invalid sanction, that forum
can
is
be raised. That's what you have.
Yes, that is settled position. And with regard to public servant, I also record my submission that realize this judgment. Let this point be raised before the trial courts. Matter ends there.
My lord, discharge application was rejected. Thereafter, I am before this honorable court.
No, this is not a groundless case.
Kindly remand the matter to examine this.
No, why? And that will be examined by the trial court.
Already
by,
examined.
by adducing evidence.
I'm
So
challenging.
Lordship is saying that evidence has to be adduced.
That has to be dealt with.
Factual aspects are there to be adjudicated in the trial only.
This mixed question of law and fact.
Correct.
No, this is not mixed question of law
And
and fact.
then
It is pure question of
to establish law also, whether that's what is
of
the
law.
license, what is the
In
license
terms of that
number?
Position, mixed fact of question of.
Suppose the license, what is the date of license?
This is a pure question of law. Whether you
No, question of law, had it been a simple cheater, you are a society, whether you are regulated by the RBI or not.
License.
All these things are
License
actually
was
has to
issued
be
by
established.
How
Then
you are
only you
functioning.
can, the trial court can.
If you are operating under the license, what is the date of license? These are to be adduced as an evidence.
What is the tone and tenure of that license?
Correct, my lords.
And whether it satisfy 46A or not.
Exactly,
All
my
these
lords.
things has to be.
Has to be adjudicated.
They are
And
factual dispute.
he will have liberty to raise all those points, my lord.
Factual.
But at the time of at the threshold,
if I am not a public servant, why shall I face the trial?
who said that you are not a public servant? That is your commission. That is a defense plea.
Wrong, right? Whatever, there is a sanction against you.
That's a plea of
Even by the
defense.
board itself.
My lord.
And you say that is the wrong sanction.
No,
Then-
no, sanction is not given by the board. Sanction is
Invalid sanction.
Ratified by the board.
rectified by the board. Out of it is mentioned that out of fear the president accorded sanction. It is sanction.
All right, it's
Again,
invalid.
these are facts.
It's an invalid.
Again, these are facts. You
No,
have
it
to,
is-
you have to cross-examine him.
Correct.
That
Bring
is in
him to the witness box. Ask him what
My lord,
authority
it
you
is-
had.
It is in black and
How
white.
have you given?
My lord, in the ratification, it is clearly mentioned.
How
সেটা
that
ମୁଁ
will-
ମନରୁ କହୁନାହିଁ, ଏଠି
And
ଲେଖା
that I
ହେଇଛି।
understand.
That is written in
So
their resolution.
You people do one thing, you give written submission and reserve the.
Deep problems.
I'll dispute. Written submission, ये कर दो. Judgment reserve, the parties to submit written submission within this thing along with relied upon judgment. Whatever provision you are quote that constitutional provision, whatever, I'll deal with everything. Yes. Next.
69.
Within a week, huh? Don't. Yes, sir.
But this is also against an order refusing discharge.
In fact, my learned friends, last occasion, my lords, highlighted, my lord, on page 6, paragraph 9, my lord, paragraph E, my lords, that one Krishna Chandra Barik is a charge-sheeted witness, my lord. He died in the meantime, my lords. And the expert opinion is not definite with regard to the petitioner's complicity, my lords. And there is no other material available to implicate the present petition. That's a main thrust of petition contention at the outset when he argued last week, my lords. I have to get instruction whether is there any other materials to indicate the completion petitioner bereft of these two facts, my lords. He said that one of the charged witness died, another, the expert, my lords, is not very definite about the petitioner's exact complicity, and there is no other.
Which paragraph he says?
Paragraph, page 6, para E, my lord. Para E. For that,
Madam, the Mr. Das, learned counsel for the name, petitioner has challenged the order dated
12, page 12.
order dated
Order dated 9/5/2024.
from 24 passed by
The Lord Special Judge
Special Judge Vigilance Cutter in PR case number 48 of 2012, whereby his application for discharge has been rejected. The petitioner has raised many points in the many point to attack the impugn order.
The main thrust.
The main thrust of the petition is postulated in para E, 6 page 6 para E of the ground, para of the ground. Mr. Das, then counsel for the petitioner, seeks time to get instruction in
the materials
with regard to the aforementioned ground.
And if there are any other materials indicating his complicity.
As to whether any other further material is available against the petitioner to
implicate
to establish complicity in the commission of the crime. Release the matter. Get the case.
Both are same rules.
Your Lordship,
So that next time we'll
give me a date because the date was fixed today in the trial court.
That will urgent, Lords. Because matter is pending there.
So your Lordship may give me a date so that I can.
Date will be
given. Yes.
I will also talk to the lower court lords.
Next time he may say that there is nothing.
If
no, Mr. Mishra is a very.
There is nothing. He will obviously say that.
Except these two, if any other material there, I have no case. I will go there.
In fact,
that's what he pointed out. That para. That's fair enough. This is the best way of doing it.
Yes.
Yes.
Item 70.
70 same man. Same.
70 same.
Another case.
Ground.
Same ground.
Same ground.
Arranging the same factual backgrounds, my lord, but two, the GPF amounts were.
No, here first one, 69 is GPF, 70 is
house building.
Almost.
Same E, ground E.
Ground E. But TR case is 48, another is 50.
No, his lordship is wanting what a para E or same or not?
Yes, para E is the same.
Correct minutes.
70, 71, huh?
Page same, para E be same.
Correct.
71.
Yes.
71.
Yes, sir.
Your Lordship directed me to.
Ours is 73. Ours is 73. Our 73.
No, it's 71.
Revision.
Sir. Your Lordship, I see the order dated 25/7.
Donga Hari something.
My. Your lordship directed me to act as an amicus curiae to assist your lordship.
Yes.
Your lord, petitioner has been convicted under section 325 IPC, sentenced to undergo RI for 2 years and fine of 500. But the allegation I was going through, the FIR was lodged against the present petitioner and others, 2 others. They have been acquitted by the appellants.
Okay.
Now, the present petitioner alone has been convicted.
Okay.
But the allegation is
Convicted by trial court.
all were convicted by the trial court.
And appellate court acquitted 2 of them.
2 of the 2 lady
And,
members.
yes.
And the present appellate, the petitioner has been convicted.
Right.
The conviction has been made. Now, here, PW1 is the informant, PW2 is the injured, 3, 4 are sisters of the informant. And other 5, 6, and 7 independent witnesses, they did not support the prosecution case. The allegation is, while this injured and the family members, they were sitting there in part of their house, the present appellant, petitioner came and asked them, don't cut the reach. This amounts to a land dispute, taking away water. The petitioner said that don't cut away the reach. It will affect my irrigation system. From that, there was a dispute, and the allegation is the present petitioner assaulted the injured PW2 on the head by means of a lathi, and 3 and 4, they were injured. These other 2 lady accused, they assaulted, for which the injured sustained a fracture on the right arm. Now, if your lordship sees the injury report, the allegation leveled against the present petitioner, the injury is a laceration on the head, and the injury caused to the hand is not attributed to him.
Okay.
So, my respectful submission is
the Thenga was recovered. Yes.
your lordship sees that.
Yes.
PW1 is the informant, 2 is the injured.
Yes.
And the injury report going to the injuries he has sustained. Your lordship kindly turn to page 7 of the appellate code.
Which injury was grievous?
The 2.
Injury number 2.
My lord.
Injury number 2.
That is not attributed to the present petitioner.
That is which part of the body?
One swelling of right forearm.
Okay.
The
forearm.
My lord.
Right forearm.
Yes. And the
And
first one,
what is attributed is head injury.
head injury to, that is item number 1.
That is 323.
Yes.
Simple.
And the
Yes. The one which is attributed to him is turned out to be simple injury, and the one which is not attributed to him is grievous.
Yes.
Trial court judgment page 18. In this case, prosecution has well proved that Hari assaulted Siddharth by lathi, causing laceration on of sides.
Whatever,
Having into 1/14 into 1/14 over the
Vertebral scarf. Yes.
Head injury. And the injury number 2 is grievous.
That is fracture.
That is the forearm, right forearm. So therefore, it is a 323.
The court below under 325.
323, simple. And undergone how much?
Next year also.
Undergone? Hard copy. Just see the undergone period. You might have undergone for some time because 307 was there. So might have been arrested. Just can you just see?
The child. 307 the charging.
Any?
341.
No, FIR 307 is. This is 307, then I think.
Yes.
For the 323, what was the sentence? 323 sentence was given. 325. There must be some UTP period because it is written UTP period that be, set up. There must be some UTP period. No, no. That's right. We will impose fine.
Or with fine.
Or with fine is there.
Okay.
And then fine, we'll put fine. Why? 10,000 fine. Huh? It's not end.
No,
So our problem is solved. We some fine to be paid to the victim as a compensation under 357. Thank you very much, sir. Thank you very much, sir. Otherwise, default sentence will be there. No?
Yes.
Default sentence will be there. Thank you very much for the assistance. Yes.
72.
72 was adjourned to 9th.
I generally pass order that the amicus curiae are entitled for some honorarium. So, out of respect,
Same maybe.
the same thing I'm just informing. Out of token of respect, this is given.
Honor.
No, long period. I'm giving the date. 2019 till Millards. Yeah, Millards. All through he was the state council. And people, public servants, that they don't dare to talk with you about anything consideration matters. They are really scared of him.
That's what one should learn.
And we respect him because he's a high level of integrity. And we are sorry because his name could not be cleared in the on Supreme Court college.
Friend with the two of the eminent judges of this court, senior just Asipatna and just
Great.
He was associate of.
His name also the collegium.
That is a very small thing for him. Very small thing for him.
The epitome of highest level of honesty. So far, government council is.
That's very important. Yes, sir. Next.
72, Ballard, again, Ballard, the same question. That in between 36 years have been done.
Yes.
36 years have been passed. And he was 63 by the time the occurrence judgment was delivered.
He's still alive or not?
No, that's we have.
My learned friend is trying his best, but
we have taken 3 attempts, 2 at his residence and 1 at his place of work, but we cannot trace him. At the last occasion, my learned senior said that.
What would be the age now?
Well, at 63 plus 36.
Let us see the
Judgment says in the year
95,
95, he was
he was
63.
63.
My lord.
Just imagine.
And
92.
92.
In fact, in the last occasion, my learned senior said that he will take an attempt to ascertain this.
no, my lord, I contacted the local lawyer. He said I was State Defense Counsel. So how, I do not know. I was engaged by the court. I have no contact with the client.
I've seen in many cases where sir's father was there. That time Vokalasan was filed. Now he's doing it. In many cases, I've seen it. He must be junior that time. He entered into profession or may not be in the profession.
He was a lecturer. Mr. Dhawal
May not be in the profession. of-
having a glorious career and academic career, my lord. He was in the teaching line as a lecturer.
He wanted to give it to bar, therefore he came. So what we'll do, sir, the other.
I think, my lord, the other point,
other group of matter. we
Yes,
can
madam.
see,
Ninth.
The point which
which you were considering.
Yes, madam. That has
and
been
that
fixed
has
on
been
9th.
adjourned to 9th.
I'll put it in the 9th.
But let me put it in the points which actually I have started preparation for that, but
I don't want to confine that anything can be evolved. If you start researching, anything can be evolved.
because Section 360 has got no application. Prevention of Offenders Act has also got no application. That I am now confirmed.
Yes.
Confirmed in the sense, my lord, I was going through a judgment of Hon'Ble Justice Prasad, where High Court had passed order with regards to a sub-inspector of police invoking power about Section 18 of Prevention of Offenders Act. Court said after amendment, when the amendment has not taken note of that, you should not, court should not have done it. High Court should not have done it. Accordingly, allowed the government of it. The government had come in that case. The question comes up when they said
before amendment, what was the position?
Before amendment, the judgment is after amendment.
So I'm talking about before amendment. See, the
Yes,
regime changed thereafter.
So, my lord,
and all these offenses
so
are much
what I want that, my lord, a question be framed, because I was trying to see the last order. So Mr. Dhawal has taken time to such and such day. Only this is the order. That was the order in the other case.
19th I will frame. What I am thinking is
9th.
19th when we will come.
9th.
9th. When we will deliberate on the issue, whatever question of law comes, I'll frame it and all the matters I'll decide on that way.
So preparation.
Let us evolve the, formulate the question also. Because whatever it comes.
Yes, that will
that
course
will
of
better
argument, my lord. Yes.
That is why I am accumulating all similar cases.
On 9.
So in one go, we will take a call. Let the
Otherwise,
we will dispose it.
70-80% cases will be in this.
Coming within this bracket.
Yes. Never-ending process.
70-80% are
But
coming.
just see, before amendment of Provision of Offenders Act, if that regime started, what was the application? Whether I see all these cases are prior to the amendment.
Yes.
Prior to the amendment. Before we can apply the unamended provision and the one which you have shown 376, that proviso.
Valid.
By utilizing that proviso, I have disposed of nothing less than 5-6 cases.
Valid.
Sentence reduced on 376.
Valid.
Convicted 7 years is minimum.
Yes.
Valid.
But in the earlier regime, Sir has shown one proviso and one judgment also. By assigning reason, the sentence can be reduced.
Valid.
And in many cases, 1 year, 2 year sentence already undergone.
Yes.
The accused is 50, 60, 70 years age. I utilize that proviso and
In most of the cases, my lord, I got, my lord, the judgment of apex court, where, my lord, they have, in case of Section 5, not, my lord, 7 or 13, what they have done, my lord, considering the fact that the mental agony the accused has undergone into 10 years or 15 years, we are passing or we are converting the period undergone and imposing fine of 5,000, 10,000, like that. Most of the cases of Supreme Court. But
and there is a judgment which you can get. The procedure is the penalty.
Penalty
procedure.
and
Procedure itself is a penalty.
And fine.
Fine.
But with regards to and fine, they are imposing fine, but with regards to sentence, they are giving this reason. Special circumstances. Circumstances, the accused has undergone 10 years, 15 years, in some cases 20 years, like that. Or I have got around
But
5-7 years.
PC cases, no undergone period. Because
During
it's
that
only one
period,
day.
during that period, they were must be in the cases which has been disposed of. We cannot get the records. There must be no sentence, but period
Or
undergone
maximum 1 day.
till rising of the court.
Yes.
So-
TRC is
But
there.
till rising of the court in absentia, I can't make it.
Yes.
Exactly, it cannot be
It
done.
cannot be done.
It can't be done.
And
That is what I got confused.
earlier before this amendment of 88 amendment, accused persons were, as it is, they were released judgment, whatever may be the DA, whatever may be the amount recovered, they were getting well on the spot.
And
They were offering, yes. So, earlier cases like that.
Now, all of us are waiting for your assistance. Yes. Yes.
73. But there is also a similar case.
Yes, sir.
where the petitioner has been convicted under section 7 of the PCR. 6 month sentence, 500 rupees fine. The allegation is that the allegation is that here, if the lordship sees, the allegation is the petitioner was working as a forest guard. He demanded rupees 200 from the informant for releasing the penduli packs.
Okay.
The informant was carrying some canoe and the petitioner detained him, kept the canoe stock in the house of a forest guard and demanded 200 rupees. 2 days after, in the market, the person comes and puts 200 rupees in his pocket. That is and there is no demand. Nobody has whispered that on the date of the search and seizure, anybody he has demanded. The money was recovered, recovery part is proved because of the recovery of the note and the hand solution turned pink, but there is no demand. And the allegation also from the judgment itself reveals that prior to this occurrence, 6 days prior to that, the present informant, he was booked in a forest case. And in order to compound that, the forester had asked him to pay 200 rupees as the compounding fees, and the present petitioner was asked to collect that money.
Okay.
That is on record. And the trial court also comes to a conclusion that the forest case was 5 to 6 days prior to the occurrence and cannot be a manufactured one. But considering the fact that the note was recovered from my pocket, I have been convicted. There is no demand. In order, my submission is, in order to constitute an offence under
He is surviving.
83.
Because in 1995, he was 43 years.
55.
No, charge sheet says 43 years.
The judgment says 55.
Bhagwan Sahu.
I've seen that. I've seen the person.
Charge sheet is, anyway, he is there surviving. So
More than 80. Acute diabetic patient and more than 80.
what is there for demand?
Alerts. Magisterial witness alerts. PW1 alerts.
PW1. Paper book is there?
No man, paper book is not ready.
PW1.
2004.
Yes. Yes, PW1.
PW1 my lords. Para 1. My lords, have it, my lords.
Yes.
On 4/9/91, I was election officer, Sambalpur. On that day, on the requisition of SP Vigilance Sambalpur, I was directed by the ADM Sambalpur to attend the Vigilance SP office Sambalpur on that day, and accordingly, I attended the office of SP Vigilance at 1:30 to 1:45 p.m. One clerk of my office, namely Dilip Kumar Tripathi and one Narayan Mahapatra, also attended the SP Vigilance office as per direction of the ADM. After our arrival in the office of the SP Vigilance, we were asked to wait in the conference hall and there DSP Vigilance. Then my lords, there is some typographical error. Then the next page was sometime thereafter, my lords. Sometime thereafter, one gentleman, namely Nepal Ranbira, was introduced to us as the complainant. There the complainant narrated about one forest guard, namely Sahu Babu, demanding rupees 200, as he was carrying 5 bundles of kenduri.
Sahu is the same man.
Same, Bhagwan sir. He also told that the forest guard Sahu had told him to pay the bribe of rupees 200 at the weekly market of Raisapalli on that day. Then, my lords, the preparation report follows. Then your lordship may kindly come to the cross-examination of the decoy, my lords. Para 4.
Yes. The currency note which were treated.
Sorry, my lords.
Currency note which is treated, that's paragraph.
No, my lord, it is not a fact that.
Which
Para 4
which
of
witness?
cross-examination.
Which witness?
PW2.
2.
Yes, my lords.
Yes.
Para 4.
It is not a fact that.
It is not a fact that I did not state to Vigilance Police that Bhagwan Sahu demanded rupees 200 from me, nor I mentioned about the demand of 200 in my report to Vigilance Police in FIR. So, my lord, the FIR is free from any concoctional embellishment. Then your lordship may come to para 7 of the same cross-examination. PW2, para 7, the last.
Sridhar Darwa.
Yes, my lord, Sridhar Darwa. Those things are not important.
It's not a fact.
It is not a fact, the last 4 lines.
I promised to pay 200.
It is not a fact that accused did not demand rupees 200 from me, nor accepted from me, and I have falsely reported against him regarding demand of bribe of rupees 200. This he has been stated in the cross lines. Because I don't know why this question was put to him, in fact, in the cross. So here comes the demand partners.
Demand is there.
So he is not the PW2 is not the person.
No, he is the decoy members.
Decoy. He has not heard.
PW1 is the complainant.
Yes.
No.
He also says.
PW2 is the decoy members, which I read right.
Okay, PW2.
Yes.
Who is PW1 then?
PW1 is the magisterial witness.
Magisterial.
Yes. Nobody says that in the weekly market while the money, he has demanded, said that demanded the money and money was taken.
Then, my lord,
constitute an offense under section 7.
No, the PW2 in the cross examination in the chief at the top, first paragraph he says.
Yes.
Bhagwan Sahu, one of the forest officers, detained me and demanded 200 rupees from me.
It is not a fact that I said.
No.
Page para 1.
Chief, you come. Chief of
PW2.
PW2.
The decoy.
At the first, second line.
In the month of Bhadrava 1991.
2 p.m.
Yes, sir.
I was coming from my sister's village.
Yes.
So and so with 5 bundles of
Kenduli.
Bhagwan Sahu,
forest officer, detained me and demanded. But this demand was relating to that to be paid to the forester to compound that case. Because if your lordship see the judgment also, the forest case was prior to the present track. In order, there the 200 rupees was the compounding fees. The forester asked the present forest guard.
Go and collect it.
Yes. So that is there. And the kendu leaf which was kept in the.
Show me your 313. Show me.
Question number 15, minutes. Question 15, minutes.
Read it. It is not there. Yes, read it.
I will not be able to read it.
Sir is there. Nobody can read it.
Absolutely not lessable. There are tribe notes.
Pandyapalli.
Pandyapalli, FG, Haradhana Pradhan, forest case, book କରିଥିଲେ और नेपाल और श्री अधरुआ नियारे से केस पकाइଥିଲେ फॉरेस्टर को एमाने केस 200 rupees compound କରିଥିଲେ 29/8/2019.
Then stand is taken. Let us see DW.
DW1, your lordship can issue.
DW. Who is DW?
DW1 is the forester, man.
Retired.
He was working as forest guard.
Forester, na?
Forest guard.
Guard.
What he saying?
No, the accused was working as forest guard under him.
So what is he saying?
He is saying, my lords, may kindly come to page 2. Page 2 of
He is retired. No, he is not retired.
Yes.
I was the forester of.
I know the accused.
She may kindly come to cross-examination page 2. Para 2. DW1 para 2. Lordship have it, man?
Yes.
I know about the vigilance case against this accused. I know that he was taking a bribe of rupees 200 in the market, but I do not know yet as to from whom he was taking the bribe.
I know that
he was taking the bribe, he knew. I know that he detected someone carrying candle leaf. This also he established.
Your witness is very dangerously disposed towards you.
He establishes two things, my lords. One, that there was seizure of candle leaf. Second, that the bribe was being asked.
You have invited this man.
If your lordship,
I know about the vigilance case against the accused. I know that he was taking a bribe of rupees 200 in the market, but I do not know yet as to from whom he was taking the bribe. I know that he detected someone.
You had taken him to depose. That no, I have not taken bribe, but I was taking the 200.
Further paragraphs are more dangerous. He goes totally against.
After the trial, I contacted the accused who told me that he was receiving the compounding fees of rupees 200 from so-and-so in the market in that forest case. He was trapped by the vigilance police. Hearing this, I did not go to the vigilance police to tell about the actual facts, showing the documents 8 to 10 days after the trap. Vigilance police met me, but I did not show these documents. It is not a fact that all these documents were subsequently manufactured, for which I could not produce them before the vigilance police. On the first page of the office book,
yes, offense book.
There are cuttings and overwriting. During my tenure, there were 6 forest guards and in 6 beats under me. Forest guard maintains the forest offense book. Then Dhruva and Ranbidi appeared before me, paragraph 5. On 28/8/91, he did not take any statement from them since they had already filed a petition for compounding the offense. It is not a fact that the FIR seizure list Jimanama had been subsequently manufactured. So admittedly, my lord, there is a first case.
I think the first para 2, he has used these words very loosely. Because he came to know, he said, for bribe he was cajoled. So therefore, loosely, and further he explained.
Para 4, my lords, which my learned senior have not placed it. I would like to place it para 4.
Yes.
That also goes against them.
Para 4?
Yes, my lord, same.
On the first page of the offense book.
I'm just placing it. On the first page of the offense books, my lord, no, offense book comes into picture because they say another case was registered. Pursuant to that case, this transaction is being carried. Now, what is the, my lords, the sanctity and the veracity of this offense book? On the first page of the offense books, there are cuttings and overwritings. And this suggests of manipulation. During my tenure, there were 6 forest guards, and the forest guards were maintaining the forest offense book. This offense book is under the custody of the forest of the present accused him. Each forest guard is supplied with a forest offense book. The original forest offense report is received by me within 24 hours, and receiving the duplicate, I mentioned this in the original. The original is either sent to the court or, if compounded, sent to the DFO through ranger. This is important. The ranger receives the compounding fees and deposits it in the treasury through challan. Forester is not entitled to receive any fees from anyone whatsoever. The entitled person is the only ranger. Regarding the case,
it's not your case that ranger has asked you.
No.
It's your case that forester has asked you. Why?
Then, regarding the case against Ranbida and Dharua, the original report was not sent to the ranger.
What sent to the ranger?
As Haradan Pradhan was busy in plantation work, I issued the letter to the accused. This plea that they have taken, that this Haradan Pradhan was busy in plantation work, not a single exhibit has been produced or proved to establish that he was engaged in plantation work. So this is an afterthought, and that particular offense book has been manufactured. The house of Hardan Pradhan is at a distance of 4 to 5 kilometers from the house of Dharua and Ranbida. So also the house of Bhagwan Sahu from the house of those two persons. It is not a fact that this letter Exhibit E was subsequently manufactured to save the accused as he was working under me. So much this Exhibit E has been is a manufactured one. It's an afterthought after this institution of this
That
case.
that is the E book. what you
Yes,
call it.
offense book has been
Offense.
tampered with because he himself does there is cutting and overwrite. And they this witness happens to their witness. He is DW1.
Yes, sir.
But if lordship sees the entire exhibits, this exhibit E is not that. Exhibit E, my lord, Siddhara Dharwa Pakita Swan Show, kon amore 41 and 27 of 1972 ଅନୁଯାୟୀ FIR number Swan Show ର ମକଦ୍ଦମା ରୁଜୁ କରିଛନ୍ତି। ସେ ଦୁଇ ଜଣ ମୋ ପାଖରୁ 200 ଟଙ୍କା କ୍ଷତିପୂରଣ ଦେବା ପାଇଁ ଏତେରେ ରାଜି ହୋଇଛନ୍ତି। ଏଣୁ ଏହି ଦୁଇ ଜଣକୁ ଗୁଙ୍ଗଲେଇ ସେକ୍ସନ ଅଫିସରେ ହାଜର କରେ ସେମାନେ ଉପରୋକ୍ତ କ୍ଷତିପୂରଣ ଆଣିବାକୁ କହିବେ। ଲର୍ଡସିପ ଚିଜ୍ exhibit E. That
is what
that is the document 29/8/1991. Bhagwan Sahu, Bonarakhi, he was directed to bring this informant.
But their cases, this is subsequently manufactured.
Yes.
And exhibit 1 is the FIR against for the first case.
For which is compounded.
Yes. And no. What? And the categorical finding of the trial court that yes, that is correct. These documents were not fabricated nor manufactured to overcome the a person without getting agreed will not take much trouble to put a man in a vigilance case. That is how he proceeds, the trial court. There is no answer to that. So I believe that the accused has taken.
Where read it?
That is page 6 of the trial court judgment.
Chalo, we'll parted. We'll
Yes.
see. Parted. And please do one thing. Get a photocopy of the same and give it to sir. के पास भी है.
My lord, this one, my lord.
Ah.
No, this is not a paper book. I have access to the soft copy only.
I give a paper
Yes, madam.
photocopy since you have done.
Yes, sir.
While
I've taken
dictating,
a
I'll have to
photocopy.
get a photocopy.
Yes,
of
sir. I will.
Parted, huh? Okay.
Possible.
Get some.
Some date may be fixed.
You will fix a date. Parted. Just see. There is very scope is very.
But there is no demand.
Bleak.
Nobody has said that there is absolutely no demand on the date of occurrence.
If anything small avenue is there, we'll find out some way of try to because he's old man. Let us
Yes, 20 years.
try to find out some way where it can be manipulated. Okay.
Careful.